has universal application, certainly for our courts, both in how we administer them and the substance of what we will be doing in the future. Today we shift to a topic that probably has a differing level of application to each of us in our respective states that we're aware of right now, but one that has the potential for concern and that we want to spend some time discussing. Thanks to a grant from the State Justice Institute, we have a videotape of the program this morning, so I alert your attention to that. It's my pleasure to present our keynote speaker on our topic, the common law movement. And we're grateful to Chief Justice Moyer for his good work in leading the development of this program, and he will be moderating a panel on this topic after our keynote speaker gives his opening remarks. Again, it's my pleasure to introduce Michael Reynolds, who is a Senior Intelligence Analyst for the Southern Poverty Law Center. He joined that center in 1994. He has been responsible for the development of a militia task force and has worked in developing information about the patriot movement in this country as it applies mainly to those elements that have potential for terrorism and for criminal activity. He has spoken widely on the topic, has published numerous articles and periodicals throughout the country, and authored his own book. It's our pleasure to welcome to the conferences Michael Reynolds.
Thank you. And thank you for having me here at this prestigious conference. I'm with the Southern Poverty Law Center. It's celebrating its 25th anniversary this year, in fact, last month. It was founded by Morris Dees and Joseph Levin as a civil rights advocacy organization. In 1980, in the course of conducting investigation for one of the lawsuits against the Ku Klux Klan in the murder of a black man in Mobile, Alabama, in the course of conducting the investigation for that suit, a project was formed called Klan Watch in 1980-81. Klan Watch is a project that was tasked to track not only the Klan, but neo-Nazi and other racist right organizations and crimes committed by individuals within that movement. In 1994, a militia task force was formed that grew out of Klan Watch. Klan Watch's activities followed leaders, organizations from the racist right movement and found them in the early stages of the organization of the so-called patriot and militia movement. One of the things that prompted that was a incident that occurred in early September of 1993. The two individuals, Linda Lyon and George Sibley, were traveling from Florida through Alabama. They were in Opelika, Alabama, about 60 miles from our building in Montgomery, Alabama. And there was a domestic disturbance reported from a Walmart parking lot. Opelika Police Sergeant Roger Motley arrived at the scene and approached these two individuals. There was a 9-year-old child in the vehicle that these two individuals were about to enter. Officer Motley requested some identification from Mr. Sibley, a 51-year-old white male. Mr. Sibley responded by saying that he did not have to show them, the officer, any driver's license because he was, quote, under no contract as a free citizen of Florida. He then reached for a pistol that was in his waistband. Officer Motley drew his weapon, and at the same time, Linda Lyon pulled another weapon, opened fire on Roger Motley, and killed him. The two then fled, were later surrounded. A short standoff ensued, There was an arrest. There were charges. There was a trial. Linda Lyon is now on death row in Alabama. She still writes of her innocence, the fact that she's a sovereign citizen. There was no jurisdiction. It was self-defense. She publishes these works throughout the movement in different publications. Linda Lyon and George Sibley were a product of something called the American Citizens Alliance that was headed by Gary Hunt. It was a common law, sovereign citizen activist organization that conducted training in what the public terms and what they term as the common law. The common law, of course, as you may or may not know, is not the common law that we normally refer to in the course of our justice system. The common law that we're dealing with is a crazy quilt that has been patched together over some 30 years, and it is a product out of a religious sect called Christian Identity. And I want to take you back now to some of the roots of this movement. Specifically, it's the work of William Potter Gale. Colonel William Potter Gale was a guerrilla commander under General MacArthur in the Philippines during World War II. He was a major architect of what is known as Christian Identity. Christian Identity is a religious sect that comes out of British Israelism, a curiosity of Victorian England that was produced out of the writings of a man named Edward Hine and two others that proposed the Anglo-Saxon people to be the lost tribe of Israel, that they were indeed part of the Israelites. During that time, however, the British Israel movement did not take up anti-Semitism, saying that the Jews were not Israelites or the chosen people. That came later. That came in the United States after World War II with Mr. Gale, Mr. Wesley Swift, a Church of Christ minister who had affiliated with Gordon Pelley, that formed the Silver Shirts, a neo-fascist organization, an American fascist organization of the 1930s. There were others that pulled together in California with Gale, and together they put together what's called Christian Identity. And in this view, Anglo-Saxon Celtic people are the true Israelites, and that the Jews are the seeds of Satan, literally the embodiment of evil, that are behind an international conspiracy to control the world through the Federal Reserve, through the federal government, through a cabal they referred to at the time in the 40s and 50s as the One World Order that we're familiar with now as the New World Order. What Gale did in 1969 is he met with Mike Beach, Howard Mike Beach, and this was the formation of the Posse Comitatus, and Beach authored what is known as the Blue Book of the Posse Comitatus. The Posse Comitatus is taking the power of the county terminology and taking it back through the Magna Carta and Old Common Law of England, saying that the sheriff is the highest authority in the land and no power extends beyond the county. However, with Gale, they pulled together more of this anti-Semitic, racist religion of identity, poured it into that, and used it as an organizing tool. At the same time, Gale formed the unorganized militia. The unorganized militia in 1973 signed on some of the most notorious and most violent members of the racist right, including the White Patriot Party, Aryan Nations, the Arizona Patriots. This was the origin of the militia movement. What we're seeing today is not something new. It's been in the works for more than 2.5 decades, 25 years. The last time it broke forth was in the 80s during the farm crisis. And that's when we saw the Posse Comitatus take hold throughout the Midwest during the times that farms, family farms, were being foreclosed. And Gale, along with James Wickstrom and Gene Schroeder, a name that I will refer to again later, who is now in the forefront of the common law movement. These individuals went organizing from the Canadian border down into Texas. They were conducting meetings in common law, in formation of posses, and in effect what they were saying to these stricken farmers who had lost their farms, who were under extreme duress, was that the Jews were behind it, and that the federal government was simply a tool of the Jews, and that anyone who came against them were simply puppets. And this went down into the state and local level. If the sheriff and the local judges were not on their side, they were against them and were considered the enemy. At this time, they conducted training in the manufacture of pipe bombs, sniping, booby traps, and in one instance they found 8 anti-tank launchers in a silo in western Kansas that they had stashed there. It came to a head with the incident involving one Gordon Call, a man wanted on income tax evasion and the advocacy of not paying income tax. He was confronted outside Medina, South Dakota, by 2 U.S. Marshals as he was driving away from a meeting that had just concluded of the Posse Comitatus. He was accompanied by his son, Yori. Gordon Call was a World War II door gunner, a much decorated hero of World War II, and he was a virulent anti-Semitic member of the Posse Comitatus. And the result of that confrontation left the 2 marshals dead on the highway, and Gordon Call fled. His son was captured. Call stayed on the run for months, moving through different farmhouses and communities that were involved in Posse Comitatus, until eventually he arrived in Arkansas and was put up in the home of Leonard Ginther, another contemporary leader of the common law court movement. He eventually died following a gun battle with federal, state, and local authorities. The sheriff in that community was killed as he confronted Call. Call died from possibly gunshot wounds. No one really knows because his body was burned to a crisp. Call has since become a major hero of this movement. But Call was not the only threat, and it didn't die with Call, and the movement didn't die. What we have now today is a direct result of that movement that was first formed 25 years ago, almost 30 years ago. What Gale took to make the common law as we know it, and is still being taught today, were the Articles of Confederation, specifically Article 2, the first 10 amendments to the Constitution, the Magna Carta, the writings of an extremist right woman out of Boston, Massachusetts, named Lucille Moran, and more importantly, the Bible. For the common law court, the Bible, as interpreted through identity and other dominion sects of Christianity, and by dominion sects I mean those sects in Christianity that view God's law as the supreme law that overrides that of any law made by man, and that this law must be implemented before the second coming of Christ, before the millennium. It is not confined to identity. And the fact that non-racist, extremist Christians, self-professing Christians, have come aboard this movement makes it far more dangerous and more widespread than it was during the 1980s. To understand how a common law court is formed, one looks at the United Sovereigns of America model. The United Sovereigns of America is a publication, propaganda arm of the common law court movement. It was organized by close friends of Leroy Schweitzer, the leader of the Montana Freemen. It was organized out of Oklahoma. And this publication has been on sale and is widely distributed through the internet, through so-called patriot meetings, through mail order catalogs, and through publications out of the patriot movement. The first thing is done is there's a training meeting. And oftentimes this training meeting will be convened in a rural or suburban community. It will be conducted by someone who has been taught or who is one of the leaders in the movement, such as Gene Schroeder. Gene Schroeder is from Campo, Colorado. He is a veterinarian and a rancher in southeastern Colorado. He was trained by William Potter Gale and James Wickstrom in the 1980s in the construction of pipe bombs, in the construction of booby traps, and in paramilitary guerrilla tactics. He is now one of the foremost common law advocates and presence in the movement. And if someone like Schroeder arrives for these meetings, in which disgruntled locals arrive for whatever reason, a committee is formed during the course of this meeting. And this committee sits and establishes, quote, our one Supreme Court. Then officers are selected, court clerks, justices, a jury foreman, and oftentimes a marshal. After this, a grand jury is impaneled to hear cases. And the first cases that are heard are what are called quiet title. Quiet title is a declaration of independence from federal jurisdiction. This establishes the citizen as a sovereign citizen, as opposed to a 14th Amendment citizen. There is an organic citizen, a natural citizen, and there is a 14th Amendment citizen. This is part of the racist component that was developed by Gale, which means that the 14th Amendment citizen is not a true U.S. citizen. He is a creature of the federal government. He is a creature that is not a true citizen. The true citizen goes back to the Articles of Confederation and the Bill of Rights, which is a free, white, Christian male. Now, these days, this has been colored and shifted so many different ways with this movement that the racism is played down, but it is inherent because it is part and parcel of what the common law comes to when you start stripping away the onion skins of this movement. So once the sovereign citizen is established, they then are free of all jurisdiction by federal, by regulations such as driver's licenses, such as registration of vehicle, because they have the right to travel. And right to travel means that they don't have to have no licenses. They don't have to have no tags. They would not register their weapons. They will not conform to any ruling of the court, including most especially child support, child custody cases. We're seeing more and more of those. So you have individuals that are drawn to this movement because of these grievances, and here's what they're taught. Okay, after the sovereigns are established and the grand jury is set up, then charges can be brought. Charges can be brought against the courts in that jurisdiction, against any public official, against private individuals, against corporations, anything that these folks have some grievance with. Invariably, the grand jury will rule in favor of the sovereign. And what is produced out of this are liens, threats of arrest, charges of treason, with the punishment being jailing or death. The original Blue Book stated that if there's a violation and a conviction based on charges of treason, the individual will be taken out and hung at high noon in the public square. These folks mean what they say at the hardcore. What's left is to understand why they do this. And what are the grievances? Who are the people that are drawn to this movement? This movement is not isolated in this country right now. At our last count, we had common law courts established in 40 states. They are easily in 50 states now. That was based on our report going back to February, March of this year. These courts are networked by the internet, through email, through meetings, through their publications, but most importantly through the computer internet right now. The grievances that are brought, number one, taxes. That's always been the main draw to the common law, posse comitatus, anti-tax, sovereign citizen, / patriot organization. Specifically the income tax, which they believe is not valid, is illegal. They believe that the 16th Amendment was not ratified. They believe that the Federal Reserve is a private corporation controlled by international bankers. They don't believe in the money, however, they don't mind taking it. Taxes are the number one draw. And in this, we find individuals drawn to this movement who have justifiable sorrow. Their farms have been taken away. Their businesses have been taken away. They have gone bankrupt. Their tax burden is too high. They've lost everything that they saw that they were to have in this country and what was promised to them. So the beginnings of this we saw in the rural areas back in the 80s and still through the 90s. But now it's reached into the Rust Belt where people have lost their jobs because of downsizing, because of the closure of plants. So it's reached much farther than the heartland of the country. The second one is regulations, and these are U.S. and state regulations. These affect small businessmen. These affect hunters. These affect landowners. They don't like environmental law. They don't like any kind of regulation on them. Something starts them on this, some confrontation somewhere in the justice system, somewhere along the line. They've run afoul of it. Fair, unfair, who knows? It doesn't matter. They come to these meetings seeking some relief. They're seeking relief that they have not found in our current system. And this is the perceived injustice of the justice system that they have. They believe the justice system is totally corrupt. They believe the justice system is for the wealthy, for the elite. It is not for them. They feel isolated, and they are prime products for a group of people to come in and say, you are isolated, you are victims, come here. We can change this. We can't change within the system, then we have the means to do it outside the system, and it is justified by the Bible, by the 10 Amendments of the Constitution, by the Magna Carta, by the Articles of Confederation, by our heritage. And our heritage leads to the racism. The racism was quite virulent, and it still is, in this movement. It was quite open during the 80s. The common law sovereignty was the bedrock for everything from the posse comitatus to the Bruder Schweigen, known as the Order, out of Aryan Nations. Aryan Nations was founded by Pastor Richard Butler, the leading neo-Nazi of his time during the 80s. He's in failing health now. The first thing he did before he established Aryan Nations up in Idaho was to create the Nehemiah Township, meaning those were sovereign, white, free citizens, male, and they established a township that was apart from jurisdiction of the U.S. government and from the state. They were an entity sovereign unto themselves. And the members of the Order who assassinated a Jewish talk show host, Alan Berg, in Denver, Colorado. You may have heard of them. They've been drummed up over the last 2 years since this movement has made the papers. And who robbed armored cars and banks to the tune of $4.1 million. Who had hit lists, who were there functioning as an underground guerrilla army. The basis of their organization was common law. To understand the racism is to understand from their view it's their heritage. It's white Christian men who are under the gun, who are being subject to genocide. These are the words they use. They're not out burning crosses in a cornfield anymore. They're not saluting the Nazi flag with Sieg Heils anymore. That's not what they're doing. They've used a new language, the language of anti-immigration, the language of anti-gay, the use of anti-abortion. They point to all of these changes in our society as evidence that the white Christian male is about to be destroyed by this federal government and by this justice system, rulings by that. You are the enemy to these people. You are the ones that they intend to hang if you don't come aboard. Now, how serious is this threat? You have tens of thousands of these people in the country right now meeting. And what is to prevent one of you or one of the members of your court from being kidnapped, taken before one of these grand juries, charged, convicted, and hanged? The only thing that's preventing that is chemistry. Because the right individuals in the right court at the right time, who are coming from their hearts, who are coming from a religious belief, a belief in their heart that they are right and you are wrong, that chemistry will fall into place. It has fallen into place. The only thing is that you have not yet been the victim. You and your associates have not yet become the victims. However, Officer Motley was a victim. The only reason that Alabama police officer is dead is because of this movement, because she believes she committed a justifiable act, and she believes it in her heart, and she will believe that should she go into the electric chair. And she will be a martyr. She is a martyr now. Michael Hill, an identity adherent, the chaplain of the unorganized Ohio militia, and the Chief Justice of our one Supreme Court in Ohio, is dead and buried because he took a bullet from a young police officer in Frazeysburg, Ohio, after he drew his weapon, because the officer had no right to stop him because he was driving with a license tag that said militia chaplain. He came out of that car for the second time. He was stopped twice by Officer May. On the second stop, in the course of some 15 minutes, he came out with a .45 caliber pistol with one in the chamber and was raising it up. Now then, what does that say about the movement? It says that he's willing to die. He's willing to put himself on the line. And if you're willing to die for a movement, you're willing to kill for a movement. And this is what we're dealing with. These aren't just cranks sitting around, because the folks that are organizing this and who have set this system up have their reasons. They draw upon a fearful body of Americans, angry Americans, Americans who see no future, Americans who believe that their government doesn't care, their corporations don't care, nobody cares. Well, right now there are people who have established themselves as the benefactors to those lost Americans. And there are two reasons for this. I put down here scam and salvation. And they can mix. Salvation being those that are in this movement because they believe they can extract a separate republic in this country. That is, by the way, their goal. Their goal is not to overthrow the U.S. government. Their goal is to establish a white Christian republic here in the United States. They are extremely anti-democratic. Democracy has been the downfall of this country, and they will argue, and you may share their arguments, and we can go back and forth between republicanism and democracy, and is this country a republic, is it a democracy, so forth. They're not interested in that. They're interested in one thing. This is a white Christian republic, and all we want is our peace. And that's what they're seeking at this time. That's the root of this movement. However, there are some very canny individuals. This is America, after all, and I think opportunity, when it knocks, is attractive, regardless of whether it's dealing with patriotism or religion. And regardless of your religious beliefs or your sensitivities, this country has always had this mountebanks and charlatans, and usually what they perform is out of religion and the flag. This goes back to Melville's The Confidence Man. This opportunity for the scam is wonderful. You have Leroy Schweitzer. I'm sure you're familiar with the Montana Freeman. Leroy Schweitzer and Peterson, Donald Peterson, the two main culprits in the so-called Just Us Township, had a wonderful thing going on. It wasn't their courses that they were conducting. They had 800 people go through Just Us. There are 800 leaders out there that were produced just by Schweitzer's instructions from the time he left Roundup, Montana, and went to Brissett. Schweitzer's indoctrinated and taught probably 3 times that number. But Schweitzer came up with something known as the Schweitzer check. Well, looking at it a little more closely, Schweitzer didn't invent the Schweitzer check. A fellow that came out of William Potter Gale's organization and out of the Arizona Patriots developed what is termed the Schweitzer check. His name is Roger Elvick. Roger's still in federal prison. Roger came up with a wonderful little check that was similar to Schweitzer's and generated $1.3 million U.S. currency out of that by writing his checks on a unfounded, bogus judgment against the United States government, which is what essentially Schweitzer did. Schweitzer learned from Elvick. Elvick's in prison. Elvick is still teaching. Elvick is an ardent Christian identity adherent. He is one of the old men of the movement, and he will be getting out of prison soon, along with Richard Von Hazel of the Arizona Patriots and the Committee of the States and the Unorganized Militia. He will be getting out of prison this year. Some of these old leaders are getting out, and they're going to be very dangerous because they are revered, because they've served their time. Schweitzer, according to the press, you hear $3 to $4 million U.S. currency that was raised. Our intelligence developed something a little bit more striking. According to several sources close to Schweitzer, before the standoff, the Schweitzer operation generated between $15 and $17 million U.S. currency that cannot be accounted for. It wasn't just the check, I want to point out, of having the Schweitzer check go out. You buy first he was giving them away, but then you got a packet for 125 of these checks signed by him, and they were made out to an account that was based on a judgment against in Colorado against the government, that it was a fractal reserve check, as I recall. And you could write this check out to pay your taxes, to pay off a car loan, pay off your mortgage. And you were encouraged to write the check for more than the amount so that there would be a return. Well, this was done, and the Internal Revenue Service cashed these checks and reimbursed. The state of Colorado did this. GMC did this. You have a tax bill for $20,000, write the check for $40,000. State of Colorado kicks you back a $20,000 bonus. Schweitzer got a percentage of this. Schweitzer was not interested in making money for himself. Schweitzer is a true believer. The money he generated went into the movement. And one of the best ways and the most lucrative thing that he did was his lien. Not only the liens made by Schweitzer and the Schweitzer court. I keep referring to that, but it was the court in Just Township, outside of Brusette. It was affiliated. He had jurisdiction all over the United States with all the other. His court had jurisdiction throughout all 50 states because it was established that way through his cohorts in other states. They were all networked together. In other words, a lien could be filed against a court in Florida. But the common law sovereign grand jury and court may have been in North Carolina, may have been in Montana, may have been in California. Multiple liens were generated. Well, what these liens did is when you look at these liens on paper, these so-called perfected liens that I have, I mentioned earlier, I have some copies of their paperwork. Copies can be made here if any of you care to. I'm not going to get into the details of that because it's a nightmare, and you can do it on your own. You'll enjoy it, okay? But what Schweitzer did with his liens, these liens would be against, say, the state of Colorado. It's the Department of Justice, the IRS, Ford Motor Company, large corporations, multi-billion-dollar liens, $2, $3, $10 billion liens, billion-dollar liens. We've learned that what they did with these liens is they have brokers offshore. That's where the money goes, by the way. U.S. currency money goes offshore. And there are investigations being conducted right now for millions, tens of millions of dollars that are located offshore generated by this movement. But here's the beauty part on the liens. The liens were brokered to emerging banks in Mexico, Vietnam, Germany, former Eastern Republic of Germany, Russia. The broker does this. He has these liens. There are startup banks in these emerging capitalist countries. And these startup banks are looking for assets, paper assets. And this broker who does business with these different countries and with these different banks says, here, I've got $20 billion worth of liens here. Put them in as your asset. You look at them, they've been filed with the courts, they look fine, and they're sold for 10 cents on the dollar out there in the market. There are banks in Vietnam, Russia, Germany, Mexico, Venezuela that are propped up by Schweitzer's paper, among others. And these banks are going to collapse. So you sell at 10 billion, 20 billion, 2 billion, 10 cents on the dollar, you do the math. That's how much cash comes back, and comes back into the offshore account. Most of what Schweitzer generated was out of these liens. There's another individual that we have to pair off and put more in the scam. Schweitzer was scam salvation. looking for salvation. That is that Christian republic, that salvation. A true believer, a religious zealot, and a scam. It's all right to scam the federal government because it's illegal and it's satanic. Joe Holland is facing 54 counts. He's from Indiana, Boonville, Indiana. Joe had the North American Freedom Council. And the North American Freedom Council had several of these common law lien scams going on. Well, right now he has 54 counts of money laundering and tax evasion on him by the IRS, by Treasury. And we understand that this is just the doorway to Joe's operations. Joe generated about $6 million, $2.5 million estimated off the brokerage of 6-point-something billion in liens. Holland was associated in a business way, if we could put it that way, with Schweitzer and his crew in Montana. Holland sent a threatening letter to one of the judges, and I don't recall which one, in Montana. Could have been somebody here. One of his blustering body bag numbers, and was charged in Montana with that. Well, when Joe Holland went to his hearing to court in Montana, what he did is he just called up and leased a jet for $11,000 for the day, paid cash for it, and made an offer of buying the thing for $6 million cash that day. That's Joe. Then we have the Hildebrands in Iowa, who have generated $2.3 million in their wonderful little scam. They go to trial in November. The Hildebrand scam was a mixture of identity true believers and opportunist scam artists looking to line their pockets. Now, here's what's going to happen with the scam artists lining their pockets and the true believers. What the true believers will do, identity wherever they're coming from, Christian Reconstructionism, wherever, they're going to tie the portion. They will tie the portion of their gains to the movement. All of it will go offshore. But a section of that, 10% of that, will go back into the movement for whatever purposes, whether it is to purchase land, to mount a political campaign for candidates, which is part of their strategy, is to take it back, taking a page out of Christian Coalition, start with school boards, get your officers elected there, get somebody in as sheriff. It's a two-pronged operation. So there's a lot of money, millions of dollars that are going to be pouring into political campaigns around on the local and state level in the country for these candidates to take office. They now have the money, and the money has been generated by the true believers through the scams. The scam artists are going to go out the window as far as the true believers are concerned, and they're going to give them up. They're going to turn them over. They're going to get rid of them. And they've already started doing that. They don't have any truck with them. So you have a true revolution going on over here, out of the heart, and you have opportunists over here looking to line their pockets, however, get the money offshore and get the hell out. Get that pina colada. Well, the hardcore of this movement, and it's the important part of this movement, doesn't intend to go offshore. They intend, as they have said at one of their last meetings I was at in the field, we want our country back. And they also said, Pastor Pete Peters, leading identity minister, says, who are we? We know who we are. We are the white Israel people. We are the people that this country was given to. This is our country, not their country. And you or they, as far as they're concerned, you are they. You are the enemy. The threats right now, I want to touch on some of those. Oh, one more thing. Excuse me. This movement right now, and I want to speak from Oh, this flag. See that gold fringe? I don't know how many of you know what that means. That means admiralty law. That means you have no jurisdiction over me. I'm a sovereign citizen. That's admiralty law. I don't recognize your court. That's what that gold fringe means. What does that mean to them? You have no jurisdiction over them because they're sovereign citizens. That's admiralty law. That's a law of the sea. That's military law. You have no jurisdiction. You may not, as Chief Justices, hear that, but many of the judges in this, if there are other judges in this room or in your states, they've heard it. And I want to point out this age group. I think this is very important before I go on. Doing field work, and I have for the last couple of years, that's how we refer to it. At these meetings, most of them, almost entirely, are white Christian males, self-professed Christian. I want to make that clear. 30 to 50 years old. That's important because that means this movement is good for another 20 years. That it's not going to go away. The true believers are not going to say, "Oh, I'm real sorry. I guess I was wrong." The true believers are not going to do that. But there's one other thing I want to mention to you that's been a recent development. This common law sovereignty has also gotten a little toehold in the urban areas, places you wouldn't suspect, places like Manhattan, Philadelphia, Washington, D.C. And where did it get a toehold there? Inner city black males who have splintered off from the Nation of Islam and formed their own groups. There was an arrest, there were arrests and charges made with a handful of New York City policemen. They were members of a common law group. They were known as the Muslim Brotherhood. That's what they called it. There are two groups in Philadelphia that have established courts that are also splintered off the Nation of Islam. They're black separatists, African American separatists. So they're using these tools, and they're being organized in the inner city to use these tools as establishing, well, first of all, they're not concerned about the 14th Amendment citizen. They don't recognize that, and they don't expect to be slaves. They don't want to be citizens of this country. They want to be sovereign citizens. Sovereign meaning independent from all of that. We'll establish our own court. We're going to rule this. This organization is going on now and is somewhat successful in Philadelphia and most alarmingly within the New York Police Department. I just wanted to touch on a little bit more about who they were. I would like to get to before we end, I would like to go through some of what we may not recognize as connected with the common law court. But these are arrests, charges, and actions of violence and high-level criminality involving violence, potential violence, terrorism, that have at its basis, these groups and individuals are coming out of the common law sovereignty movement. Just a few days ago, there were 8 individuals arrested in western Washington, charges of manufacture, possession, and conspiracy to transport explosives and weapons. These individuals and the leadership described themselves as freemen. Viper team in Phoenix, Arizona, the leaders of that organization were also sovereign citizens and were produced out of the common law movement. 2 of those individuals we knew about before the arrest because of their activities in common law, sovereignty, seminars, and private meetings going back to 1994. The Aryan Republican Army The Aryan Republican Army was also known as the Midwestern Bank Bandits. They were the leading cell unit of several cells of guerrilla terrorists in this country. They committed 22 bank robberies involving pipe bombs and various disguises, including authentic badges of U.S. Marshal Service, FBI, so forth and so on. One of the leaders of that group was found hanged in his jail cell. So he's not testifying. He was the only one talking. Their organization was based upon the Bible and common law and identity as well. That was the justification for the formation of their guerrilla army. Ray Lampley, an individual and identity minister in Oklahoma, was also a member of the common law court there in Oklahoma. He has been convicted and sentenced for conspiring to blow up the IRS and our building. Michael Hill, I mentioned already. The bank robbers who have struck Spokane, they're known as Phineas priests, which is the equivalent of, say, Hamas. They are dedicated identity terrorists. They've robbed the same bank twice in Spokane. They bombed a newspaper office, and in the last robbery on June 12th, they kicked in the door of Planned Parenthood and threw in 3 anti-personnel pipe bombs. It was, as the sheriff said, it was a miracle nobody was killed, because the ladies who operated the office, where no abortions were performed, just happened to take a meeting that afternoon, decided to go out and meet elsewhere, go to another office. So the mother and daughter in there would have been certainly injured, if not killed. They destroyed the interior. The militia of Montana is headed by John Trockman. John Trockman in 1992 did his quiet title. He's a sovereign citizen. He does not recognize the federal government, despite what he says on television. He was a longtime affiliate of Aryan Nations, identity adherent. The Minnesota Patriots, there are 4 individuals now serving federal time who were the first individuals charged in the 1989 Biological Terrorism Act. They were products and participants of the common law court. They had enough ricin, a extremely deadly poison, to kill 1,400 people. They were going to mix it. They had mixed it with DMSO, a chemical that will penetrate the skin. They were going to put it on the door handles of judges and IRS. They had a target list. You put it on the door handle. You grab your door handle. It goes through the skin. You've got a few hours. You're going to be dead. The only reason they were caught is because one of the wives took a slap from her husband, and she picked up the evidence and took it into the sheriff's office, and that's the only reason they were caught. Terry Nichols, charged in the Oklahoma City bombing, is a product of the common law court movement, product of Posse Comitatus and Christian identity. He's far more interesting than Mr. McVeigh as far as the Oklahoma City bombing. A lot of intelligence and information coming in surrounding that points more toward identity and what we're calling common law than it does any neo-Nazi organization. Mr. Nichols was heavily involved in the common law. He had done his quiet title. He networked frequently and often with members of the common law court movement and identity in the years and up to April 19th, 1995. So with some of those examples, you can see that this is not a minor threat, and I haven't touched on some others. So at best, what you face out there in the court's face is verbal and paper harassment, disruptions in court. You're going to have contempt and refusals going on. That's at best. At worst, as I say, if the chemistry's right, if the people are right together, you're going to have violence. You're going to have bombings. You're going to have kidnappings. You're going to have assassinations. And that's just a roll of the dice. That just means that the right believers get together. They have the weapons. They have the training. they are angry enough and there's enough leadership in that particular cell, in that particular state, at that particular time, that's what's going to happen. I don't want to address any solutions. I understand there's a panel coming up. I hope I've addressed what it was a very complex subject and a very lengthy subject. I appreciate you listening to me at this early hour on something that is a bit mind-numbing at times. So I want to thank you. I will turn it over now. I appreciate your time.
Will the panelists please come forward quickly, promptly. We're going to work right through and not take a break until our scheduled break until 11, and then of course we want to be back to hear James Reynolds, who will give us the perspective from the federal law enforcement perspective. I'd like to thank Mike Reynolds for setting the stage for us on a topic that we wish we didn't have to discuss, but unfortunately I think we do. I want to also thank Mike and the Poverty Law Center for the assistance they have given us in Ohio and I know other states in simply opening our eyes to the fact that we have among us large number of people that are not just a ragtag group of disaffected citizens, but a very highly organized and focused group of people who want to change our system. The panelists, I'm not going to go through their bios because you have them, and they'll have an opportunity certainly to express to you their experiences, which is the most important reason they're here. We have two judges who have had considerable first-hand experience in dealing with the freedmen of the common law court movement. We have Susan Hansen, who is a senior reporter for the American Lawyer. One of her articles was at your place, and Susan continues to look at the issue from a very broad perspective, national perspective. And of course, Michael Zimmerman, Chief Justice of Utah, chairs our program committee rather, and has had some experience with the movement in Utah. Susan Koniak, unfortunately, is not here. I would recommend, though, her comprehensive and lengthy what will be a law journal article that's at your place. Susan has also done a very, very comprehensive piece of work on giving us information we need about the roots, the origins of the movement, and the impact that they are having in some states. Let me attempt to put in I'm not going to dwell on Ohio's experience except to make a few points and then get on with the panelists. But let me see if I can put in perspective, which Mike, I think, did very, very well. I'd like to go back even a little further and back to John Locke and the founders of our country, who, of course, had read Locke and Montesquieu and all the other great writers of the time. The founders of the 55 delegates to the Constitutional Convention, I would think it's fair to say that all of them believed in John Locke's premise that each of us is born as a free individual. We have virtual 100% freedom and liberty when we are born. But that over time, men and women have decided that to live peacefully and with a certain amount of security, they must give up some of their liberty, some of their freedom, some of their personal discretion. And so we form contracts, constitutions and laws, of course, which define what those responsibilities are going to be to each other and what rights we have and what rights we do not have. I think most citizens in our country still, whether they realize it or not, at least intuitively, they agree with that as a premise for our democratic institutions and the way in which we live in our country, with all of the deficiencies we have, with people not taking responsibility and so forth. I think that is still the basic premise in most people's minds of how it is we're able to live together. Well, it seems to me the common law court movement, the Freeman movement, this group of citizens does not believe that. What they believe is that, and they've said it very loudly, very clearly in their documents and in their public statements, is that we can decide which laws apply to us. Because as Mike Reynolds says, they don't believe that we have the right to adopt laws or even constitutions that define these rights that apply to everyone, including them. And so they pick and choose. They decide which laws bind them. They use the laws that they would like to use to support their goals and their doctrine, but of course they throw off those laws that that get in the way. Many of them economic laws. And so it seems to me that in our discussion, and for those of you who have not yet had an experience with the common law court movement, I hope you'll be thinking of the movement in that way. It is a challenge. It's a challenge to all of us who believe in an orderly society, and a particular challenge to those of us, those in law enforcement, and to those of us in the justice system, because we are the target. We are the ultimate. We are where they have to go to get the relief they want. Let me give you a couple of examples of where I think, from our experience and from my readings, what I think they want in a very topical way. We had a bank in a small county not far from Columbus, Ohio. Ohio has, as you know from the readings, we're a hotbed. We don't know why, but we are. We have 88 counties, in 66 counties, the law enforcement persons who are keeping very close watch on them and giving us information. Tell us that in 66 counties there are common law court movements. Our judges and court personnel report from 44 counties that they have seen activity in their courts, varying degrees of activity, some very intense and some just a smattering, the kinds of things we get from any disgruntled citizen, in which which doesn't concern us very much. We have a bank in a small county that had a deficiency judgment on a car loan. A person defaulted on a car loan, typical case, and the car now, the loan was up now for deficiency judgment, $10,000 deficiency judgment. The judge told me a few days after the matter was to be heard, the deficiency judgment was to be heard, that the bank officer called, a lawyer called and said, we're not coming to the hearing, dismiss the case. And they were asked, of course, why, and he said, well, we don't want to deal with these people. It turns out that the person was a common law court follower. We don't want to deal with them. We don't want to worry about them. We don't want to be intimidated or threatened. Well, who won in that instance? Obviously, the common law court movement won that one. Another example is a case in which and I think, I'll make the point because I think that's precisely one of their goals is to Susan Hansen has referred to 1 million bee stings. You know, it's not so bad if a few pieces of paper flow into a clerk's office that are obviously shams and bogus, or it's not so bad if the chief receives a letter saying, "Oh, you." Or intimidate. 1 million bee stings. Just the constant sort of effort to intimidate and to chip away at those of us who work in the institutions. Fortunately for us, a jury in a rural county, Guernsey County, Ohio, with a judge who was a very competent, cool-headed judge, had a case in which a common law court person was stopped on the highway by a highway patrol trooper. The person jumped the trooper as he was going back to his car, and he was, of course, charged, brought into trial. First attempt to try him, the judge found that the defendant wouldn't speak, literally would not speak. And so the judge, after spending a great deal of time with him to try to get him to comply with the process, found him in contempt, and he wound up in jail for some period of time, not long. He then came out of jail. He's back in trial now, and now he's trying his own case, and he asked the jurors of voir dire such questions as when was the last time you read the U.S. Constitution? Of course, no juror would, last 2 months, 3 months, no juror raised their hand. Cited quotations from the Bible, asked what they meant, no juror raised their hand, and then said, well, of course, this jury isn't fit to try me. And then attacked the jurisdiction of the court to even try him in this case. Well, fortunately, the jury saw through all that and found the person guilty, and he was sentenced maximum sentence. A good signal to the common law court movement, a very different one than that bank official who made the wrong decision. But I think that's what we face is our ability, that is the justice system's ability, to draw a line in the sand and to say, you are no different than anyone else. You can intimidate. You can even do some of the things or threaten to do some of the things to which Mike Reynolds referred, but we're not going to treat you any differently than we do anyone else. And you can make all the threats you want. You can jump the counter. You can do whatever you want. But we're still going to pick you up if we see you weaving down the road. We're not going to say, well, that's too much trouble to arrest that person because he's a common law court person and he's just going to give me all kinds of trouble. I'm a police officer if I arrest him, so I'll just let him go. We're not going to do that. We're going to treat you as we treat everyone else, and you are going to have to live by the laws of this society if you're going to continue to live here. Well, maybe that seems like an oversimplification, but that is precisely the challenge, as I see it, that they are giving us. They hope that through intimidation and through sheer frustration with the volumes and volumes of scam and junk paper they send our way, that we will just give up and we'll just feel that it's not worth the time and effort and the risk to challenge them and to make them live by the laws of our society. Well, I want to make a couple more points and they'll be very, very, very quick. What have we done in Ohio? And I'll do this very quickly. I want to say this: we have very strong support from our law enforcement, all law enforcement agencies. I read a column not too long after Montana started. Well, it was that really several weeks after the Montana incident began. A column that really piqued my interest, and it said that and we may want to have some response from those from Montana that if law enforcement had moved more quickly on the persons who were holed up on the farm in Montana, the FBI would not have had to be. In fact, they wouldn't have been holed up. They wouldn't have had the children and the women there with them. If they had been treated like anyone else, the situation wouldn't have gone that far. Well, whether the premise is correct or not, I don't know. But it's something about which we all need to think. And so law enforcement in your state is critically important, that they are not intimidated by the common law court movement. Our General Assembly adopted a statute that says that tells the county recorders what liens they can file, what documents they can file, what documents they cannot file. It's a fine-tuning statute from that standpoint, but it also gives a person against whom a bogus lien is filed a cause of action against, of course, the person who has filed the bogus lien. That was just passed. We've had no experience with it yet, but the leader of the common law court movement testified in the House hearing on the bill and said that the members of the committee were guilty of treason if they adopted this statute. And he said, of course, you know what the penalty for treason is, and left it there. Well, the bill moved to the General Assembly very quickly, and the governor signed the bill, and so we now have another statement, I guess, of the line, how the line in the sand is going to be drawn. We've increased security measures, which I will not discuss in detail, certainly. We've shared information. I think one of the roles of chief justices and state court administrators is to give support to the trial judges and other judges and court personnel who are on the front line much more than we are, much more vividly, I think, dramatically than we are, and to give them support, share the information with them, let them know that you are concerned about the issue. And I know this is controversial, but in my view, you have to speak out about it. You simply cannot say, well, if I talk about them, it's going to raise them up and give them some stature. They already have all the stature they want. And what most citizens do not have is information, adequate information about the motives, what drives the common law court movement, and they need it. They need it very, very badly. And so obviously I'm on the side of saying that we put the bright light on these persons. And I want to end by not just because Susan Hansen is here, because I've been extremely impressed. On this issue, the news media has been 100% with us, and by with us, I don't mean that we feed them information and they don't look at it critically and examine it and go do their own research. The Columbus Dispatch 2 or 3 months ago, the major newspaper in Central Ohio, did a very comprehensive Sunday story on the common law court movement. I can't tell you how many lawyers and judges said to me after reading that story, I didn't realize those people were like that. I didn't realize we had that problem in Ohio. And knowing that, of course, now, hopefully some citizens will not be attracted to their meetings where they think they can go and get their foreclosure action dismissed or whatever. I'm going to end with another example, and it's one. It's not a pleasant example, but it's one I think it's dramatic. In a state bar association meeting where we had a breakout panel, and I and some others were discussing. Somebody from the audience rose. He was a mayor, a lawyer, a mayor of a very small town, and he told us of the story of a person in his city who, an educated person, who went to a common law court meeting and then began a meeting with the leader of the common law court movement then over an economic problem. I forget it was a bankruptcy or what it was. It was an economic problem. He went to them because he thought they could help him out of this economic problem he had with the court system. He finally, of course, realized at some point that this was all bogus and that they could not help him at all. He was so desperate and so frustrated that he took his own life. Now, a dramatic story, one instance. Obviously, there were other conditions, but I give the example because I think there are some among us, as there were in our state about a year and a half ago, who knew nothing about the common law court movement and thought it had no impact on us. So, with that, let me introduce first Susan. Well, let's start with one of the judges, Jeffrey Langton. He's the presiding district judge in Hamilton, Montana. I would guess he would have Jeffrey. I would guess you would have some information about your own experiences that would interest us. Why don't you just sit there?
Thank you. Is this on? Thank you, Chief Justice Moyer. Let me tell you just a little bit about my jurisdiction so that you can appreciate some of what I'll say. I'm in a one-judge district. I'm the general trial judge in that district, having general jurisdiction over felonies and civil cases and so on. In 1994, this problem came to our area. We're a fast-growing county, and we have about 32,000 people, about 34 practicing attorneys. It's a very conservative area. There's a lot of gun ownership in our area. It's a very law-abiding area. We've had historically a low crime rate. We have a very understaffed sheriff's office. I think there was, at that time, about 15 uniformed sheriff's officers for the entire county, and it is a large county. There were two flashpoints that got things rolling in our area. One was an IRS raid on some people named Mark and Cheryl Andra in Florence, Montana. They were Mark Andra was a licensed insurance agent who was also very active in the tax protest movement and gave seminars on how to battle the IRS and had not filed tax returns for quite some time. Finally, in the the fall of 1993. He was, his home was raided by the Criminal Investigation Division of the IRS, armed with a federal search warrant. In the midst of the search, Mrs. Andrew called our county sheriff and told the sheriff that their home was being invaded and they needed assistance. So the sheriff's office responded, assuming it was burglars or some sort of home invasion, and found the IRS. And once they observed the warrant and credentials, and they stood by to keep the peace while the search continued. Well, the Andrews subscribed to the theory that you've heard, the county supremacy theory, that the sheriff is the highest earthly authority within the boundaries of the county. And they could not understand or could not appreciate why the sheriff didn't arrest these people, enforcing this warrant from a court they didn't recognize. And they attempted within a few days to file a large multi-million-dollar lien against the sheriff and IRS agents involved. Fortunately, our clerk and recorder had the presence of mind to come to the county attorney. He said, "Don't file it. You don't have to file it." She refused. The next step then was they issued what was called an affidavit of truth. It's a lengthy document directed to the clerk and recorder and the county attorney. And the sheriff telling them that if they didn't do what they were instructed to do, then they would be subject to liens and treble the original amount. They refused to act, and then the clerk and recorder refused to file those. There were attempts by them to file private criminal complaints with our clerk of court's office. I instructed the clerk to refuse those. They next filed a mandamus suit asking me to order the clerk and recorder to file these liens. And we had a hearing in court, and I'm still not sure if I made the right choice or the wrong choice, but as I heard law being mischaracterized and absolute falsehoods being stated in court, I began to engage these people in a dialogue in court to point out the fallacy in their thought process, and multiple fallacies. And this culminated with my dismissing the suit there in open court, and what almost turned into a riot in the courtroom. And in the process, I made one of their theories was that the oath of office was constituted a contract between the public official taking the oath and every member of the public, and that if in the opinion of any member of that public the official had violated his oath, then they could file liens against him without any kind of judicial process. And I pointed out to them that was not the case, that the oath was a requirement of the Constitution. It was an incident of public office. It was not a contract in the sense that they were arguing. And that just made these people livid. And ever since then, that's been embellished within our local movement, if you want to call it that, to the point that I had said that the oath was a mere technicality. At one point they said I had said that the Constitution was merely a technicality. And part of the problem, I think, with the judge dealing with these movements is that you're really not free, as you all know, to simply respond, and nor should you necessarily respond. But these people are prolific letter writers, letters to the editor. The press seemed to enjoy them because they were always wanting to give press releases. They always had dramatic and crazy things to say, and so they were constantly being quoted in the press, misquoting me or mischaracterizing some decision of the court that they found offensive, and as a judge, you really weren't free to respond in any kind of public way. I won't get into other details, but among other things, I've been the local common law court, which has been somewhat subterranean, has arrested me and released me on my own recognizance without need for any court appearance. I've been convicted and sentenced to death. I was somewhat honored in the sense that as a judge I was to be hanged, whereas the sheriff and county prosecutor were to be shot. I'm not sure why the distinction, but the most difficult problem that I've had is trying to maintain some sense of balance when you're dealing with these things. Because on the one hand, we are in a democratic country that's not tidy. There's a certain degree of messiness about democracy that we have to tolerate, and it's one of the strengths of our country. On the other hand, we're dealing with a very threatening, in-your-face movement, and until you've personally experienced the rage and the intensity of these people, you really can't appreciate it. There's no way that we can stand here, no matter what we tell you about what happened, and make you feel what it's like until you have a courtroom full of these people that want nothing more than to overthrow you, everything you represent, and would not, in your heart, it would not bother them to see you dead. F. Joe Holland had sent me the letter that our first speaker referred to. In that letter, he had said that I was guilty of treason and subject to the penalties of treason. That he talked about Fish and Game officers in the situation being my agents. He said your agents will come home in body bags. That ultimately led to his being charged in Montana with intimidation and criminal syndicalism, and that's on appeal right now to our state Supreme Court. He ultimately pled guilty to criminal syndicalism, saying that he wanted to challenge the constitutionality of the law. I think another, and I'll turn the table back in a moment, but one other point that's difficult in dealing with this movement is the First Amendment. First Amendment concerns is they obviously have the right to state what they want, and the Brandenburg versus Ohio case and more recent U.S. Supreme Court rulings, they have a great deal of latitude to say what they want in terms of incendiary speech before they cross the line. And it was difficult to explain to the public why these people could get away with as much as they did before they were actually charged with it. I had little old women in tennis shoes coming up to me saying, they're wanting these people to be taken out of their ranch at one time and feed first, and could understand why the sheriff wasn't up there having the place under siege. But I had to explain to her at that point all he'd really done was this particular gentleman was facing misdemeanor charges for not having filed a state income tax return. Well, he hadn't renewed a $50 elk farm license, but he was talking in terms that Saddam Hussein would appreciate, that there'll be rivers of blood, that there can be no cleansing without the shedding of blood. And these were over things like driver's licenses and elk licenses and car registrations. So the smallest detail, the fringe on the flag, I heard about that. Zip codes. We had near riots in court over defendants who said they would refuse any mail with zip code on it, because that somehow signified their bonds to this country that they reject. And I had to say, you'll be treated the same as everybody else. If you don't receive your notice of hearing because it has a zip code on it, then I'll issue a warrant for your arrest, and we'll go from there. But it's calmer at this point, and if there's more interest, more details, I'd be happy to provide you.
Thank you, Judge Langton. What I'd like to remind the panelists to do is, after you make your statement, such as Judge Langton did, panelists should feel free to discuss with each other points that you've heard. And then we do want to leave about 20 minutes at least for time for questions from all of you. Chief Justice Zimmerman, is there a chance that we are overreacting to this movement, that we would do better to just take each case as it comes and treat it as we often do with the filings of persons who either don't know the system or simply don't care what it is they're filing? We've got the First Amendment rights that Judge Langton referred to. What's your view of whether we are coming close to trampling on those rights? Do you have any cautions for us?
Well, little background in Utah, we haven't called them common law courts people. We've had what we used to call townshippers, their addresses have to be township and range, because they don't want to submit that they're part of any other political entity. It's kind of a county movement, I believe. We have the tax protesters and the barterers. We have the polygamists, who it all tends to be kind of the same crowd. We haven't always identified them, I suppose, as common law courts people, although it sounds like a lot of their belief systems are the same. We've had judges with liens filed against them, against their houses, which they've had to have removed from hiring lawyers. We have people who drive without registration and get picked up and go to the justice courts and demand jury trials, and then they get a de novo appeal to the courts of record and they ask for another jury trial. And the municipalities and counties that run the justice courts financially can't stand all the jury trials, and it becomes quite a burden on the system. So we have these sorts of things going on. Wholly apart from, it seems to me, my own view is that the courts are open to anybody to file just about anything that's within the parameters of what we accept by way of legal action. Bogus liens, clearly not, although it's interesting how difficult it is sometimes for clerks to determine whether a lien is bogus, because they always bring something from another jurisdiction into your jurisdiction and argue full faith and credit or something like that. But certainly those are improper activities, and there are laws against them, and there should be laws and procedures against them. And when people violate the law, and I think the Montana example and some of the others, people eventually get prosecuted. Tax protesters eventually go to jail. The township and range crowd eventually gets penalized in whatever way is appropriate for not getting car registration or for assaulting officers in the course of arrest. So that we are not without power through the criminal law system to deal with these people. It seems to me, though, that we have to be careful in trying to, at the front clerk's desk or in the courtroom, distinguish them from simply the misguided, the pro se litigant who's got a grievance of some kind but can't articulate it well, and single them out for harsher treatment or more punitive treatment. I'm sure that what Judge Langdon says is correct. When these people are in your courtroom, and repeatedly in your courtroom, it's a lot harder to be dispassionate, but that's really what our job is. And the courts are open to cranks as well as other people. They're open to common law courts people, so long as they don't violate the law. If, in fact, you have a problem, as, for example, we have with these de novo jury trials, in justice court, the answer may be you get rid of jury trials in justice courts for misdemeanors, which the U.S. Supreme Court says you can do, so that you remove some of the avenues for abuse. And it may be that when they find holes they can exploit in our system, we need to remedy them just like we remedied them any other time. But it seems to me, and I might differ a little with Tom about this, that the bank in Ohio that chose not to pursue somebody for $10,000 civil judgment exercised the same kind of judgment that somebody might when they're up against a real pain-in-the-butt litigator and they decide to settle a case rather than deal with them. That's a judgment that individuals make in their private dealings, and it seems to me if they choose to let themselves be intimidated by a common law courts person, that's a choice they make so long as the person's behaving lawfully and law enforcement hasn't proceeded against them. On the other hand, from the stories we've heard this morning and the things I'm aware of, law enforcement officers don't seem to me to be slow to cite somebody with no tags or to arrest them when they assault them. I think law enforcement takes that as a challenge. I haven't seen law enforcement be intimidated in any way by these people. So I think you have to exercise, my own view is that we need to exercise a little caution in how we deal with these people, that we don't overreact, recognizing at the same time that the law needs to be enforced against them, the criminal law, and the civil law to the extent that, eventually it slowly grinds them down.
Susan Hansen has written an article that is at your place, a very comprehensive article. She has been working since then, following the movement, and has covered some trials and has a view of what is happening in some states to persons who are treated as everyone else is treated in the justice system. Susan, in addition to whatever else you were going to say, I'd like to ask you to comment on if you have any impressions on how the common law court movement is being met by the justice system, particularly by courts.
Well, I think in the last 2 or 3 months, a number of the leaders have been arrested or are under indictment. I'm just referring specifically to, I was at a common law training school in Albuquerque in March, and I know that at least 3 of the speakers who were at the training school, one is Wayne Gunwald from Oklahoma, another one's Elizabeth Broderick, and another guy, Dennis Logan, who's from right on the border of Missouri and Illinois. All 3 of them are in, Logan is under indictment right now. It's either for tax evasion or for the filing of these liens. So, I mean, it seems to me that there's a lot of response out there, and it'll just be interesting to see what happens when with a lot of the leaders in trouble, what that does to the momentum of the movement.
Judge Moore, we also have a handout from you in which you've given us sort of a checklist of things to look for and ways in which to respond. Perhaps you would like to elaborate on your list that you've given us.
The checklist that you have in your materials is basically developed for courts of limited jurisdiction judges. Those are the judges that I'm used to speaking with. I became involved in the Jordan situation when it started with the original 22 freemen. We didn't have a knowledge base to draw from on what to do or how to handle this. There were small isolated incidents across the state, but nothing of this magnitude. So it was kind of stumble along and learn as you go, and boy did we learn. These people are masters at disruption. They have a master plan. The leaders were easy to pick out to begin with, and the followers were also easy to pick out. One leader I dealt with was Rodney Skirdall. Leroy Schweitzer trained Rodney, and then Daniel Peterson, he jumped on the bandwagon. I don't know how he assumed his leadership role in the Freemen movement. But these people, they had videotapes, one of which was introduced as probably the best evidence that the state could have at the trials that I had, and the defendants introduced it, and that's when they took over the courthouse in Jordan. They just walked in and said, we're citizens, we're taxpayers, we're taking over. They were citizens, they weren't taxpayers, they did take over. And the sheriff said, fine, go ahead, I just want to be able to videotape this proceeding. And they said, go for it. So all they did was take a pointer, and at the trial is, this is him, this is him, this is him. You know, it was pretty easy, and faces and the whole ball of wax. These people want to frustrate you. They want to frustrate the system. They want you to make a mistake, or, well, you is me, to make a mistake. They want you to get angry, and they'll try everything. I have paperwork in your materials from Utah, some of the documents that are filed. I have 6 file boxes that I received over the course of doing the trials with these original 7. And you have to read this stuff. A lot of it would be lawful precept, and there'd be a 30-page document that says, there'd be a paragraph, I, Gregory P. Moore, knew or should have known that this is a bogus indictment. I, Gregory P. Moore, should have known or knew that Nick Murnian is a, well, I won't say the exact words that they said because they don't bear to be repeated, phony, etc., and this whole thing, and at the end of it, I have to sign this, and I have 10 days in which to return it signed, and if I don't sign it, they take default judgment against me and whatever amount of money they put on this precept. So if I don't sign it, I lose by default. If I do sign it, I lose by admittance. And I'm kind of proud to know today that I own part of a bank somewhere.
I own part of it too.
The liens that they filed against me, we totaled them up one day. Yep, when you're dealing with these people, the only way I made it through sane is with a sense of humor. And I use that a little bit when I speak. But the liens total $1,400,000,000. And I'm thinking, holy cow, this is great. Of course, I've got some friends of mine that told me if they thought they were good for it, I'd have been a Gone Johnson a long time ago. Also, I received warrants in the mail similar to Judge Langton's that I was charged with treason. I would be arrested, tried, convicted, and hung. Well, of course, some of my friends came to my aid and said they can't hang you because you don't have a neck. And then... Also, if you've ever been to Jordan, Montana, eastern Montana is somewhat void for trees. But they had that figured out. They told, well, the sheriff said, where are you going to hang me? We don't have it. They don't have a town square. And he said, well, we're going to hang you from the bridge. And it's interesting to think that they have nothing to do with government, but they're going to hang you from a government-built bridge. And these things were brought up to them. I think some people kind of poked a little fun of them out there. These things always came into my mind, again, like I said, to help me keep my sanity. But the myriad of documents that they would file, and the simple procedures, initial appearance. I did an initial appearance on one husband and wife couple. Thing that usually takes about 15 minutes took over 2.5 hours. And it was a circus, the things that they would come up with. You try to ask them their name. That's not my name because it's not a capital K. It's not a capital C. It's not this. It's not that. Are you a justice of the peace de jure or justice of the peace de facto? And I'm thinking, well, de jure, that's of the day, that's me. Yeah, that'll work. You know. And these are the things, and they'll stand in front of you. Rodney Skirdall, he's quite an individual. He likes to stand, he likes to intimidate. And basically, there's only 2 things that intimidate me in the world, and that's God and my wife, and not necessarily in that order. But Rodney, when I did an initial appearance on him, my wife had the dubious honor of being with me, and she was deathly afraid of this man. And when you're doing an initial appearance in a justice court in Montana, we're rural. We don't have a lot of elaborate facilities. The majority of the buildings were built back in the early 1900s. Garfield County Courthouse, where I held a lot of the proceedings, is not as big as this room. Now, this is the courthouse, and that includes all of your assessors, your county commissioners, appraisers, the sheriff's department, district court clerk. We're talking all of this in one building, the courtroom. You have a podium about like that as where the judge sits. Your back's against the wall. There's one way in, one way out. When you have a trial nowadays, the people that show up are the prosecuting attorney. The defendant may be defense attorney. When the freemen show up, the place is packed. They always show up with their documentary team. His name was Lyle Chamberlain, gentleman about 6 foot tall, looked like he belonged somewhere, wearing a pair of bib overalls and a pointy black hat, making moonshine somewhere, beard down to here. I asked him, what is your particular function? And he said, I'm making a documentary. This man doesn't know how to spell documentary. The purpose of the videotape was to videotape anybody that had anything to do with the case, and then later they were targeted as individuals. If you didn't do anything that they wanted you to do, your name came onto the masthead of the next lawsuit or the next precept, whatever it was. In the jury trial, they wanted to pan the jury. I would not allow that to happen. And I specifically instructed them, if I see a camera, and I had a bailiff specifically watching, anyone panning that jury, I will confiscate the camera and I will confiscate the film. And then in the back of my mind, I'm thinking, can I do that? In the front of my mind, I just did. And I was going to stand on it. I was willing to go to the Supreme Court and argue my particular part of that case. I called 45 jurors for one of the husband and wife team's case. 2 days before the jury trial, the jurors received documents in the mail, the lawful precepts, 30 pages, saying that you as a juror knew or should have known all of this other stuff, that I'm bogus, that the county attorney's bogus, that the law is bogus, etc. And that if they didn't sign off on this, $10,000 and they were subject to arrest. Well, jurors started to call me. We had to dismiss that jury. We had to call another jury, and then you're dealing with these people. You're a judge. You're trying to protect their rights. They don't understand that you're a referee to make sure it's fair for both sides. They just want you fair for their side. Changes of venue. They wanted to change a venue. As soon as the state said, I don't oppose that. Wait a minute, we don't want it now. Whatever the state wanted, they didn't want, and they wanted to have everything that they could. One of the defendants was pregnant when this first started, and one of her motions was that I would have to allow her to breastfeed her child at the defense table. Well, I've seen a lot of things in my lifetime, but I didn't think I wanted to see a child being breastfed at the defense table in a trial. I thought it would be disruptive, and I denied that. And my God, the wrath of God came down upon me. Mother's rights, family's rights, everything that could possibly the American stands for, the Constitution does. So it was a disruptive proceeding, period. One of the highlights of it was the venue was changed to Miles City, Montana, Custer County. The sheriff, and then this is one thing I tell everybody in Montana, just because it's happening in Jordan or in Garfield County doesn't mean you're insulated from it. Changes of venue come in. Hey, I move in, I take your courtroom, I need security, which we don't have a lot of in Montana. We are proud of being individualistic and rugged. We want to take care of our own problems. We don't think we need all of that. Well, we're having to reevaluate in a lot of places. But in Custer County, the sheriff, I went in, I know him, very good man. He's originally from Garfield County. He knew most of these people. Told him what was going to happen and the security that we thought we might need. And the district judge there wanted security in the courtroom. He wasn't involved with that particular trial, but he wanted that, and I will honor anything a district judge says, because he might hear my appeal. But we went in there. One of the prerequisites for being a deputy in Miles City, Montana is you have to be at least 6 foot tall, weigh between 230 and 280 pounds, have 7% body fat, be able to lift up the back of your car and change the tire with your other hand. These people pay attention to that, and so do I. Judge Langton and I were noticing here, we haven't seen a lot of these people that wear the Ray-Ban sunglasses with the bulges under their arms and the little earpiece here. We have 52 Supreme Court justices here. If I wanted to make a statement, this would be the place to do it, I would say. But anyway, we went in there, and of course they all want to, one of their members wants to represent the whole group. They're not licensed attorneys. You deny that, well, then you're violating everything common law that you could ever ask for. They refuse to answer everything. They're totally disruptive. I pointed to the door with Mr. Skirdall. All I did was just make a motion. I got about there, and he disappeared. I thought he went through the floor. He was gone that quick. They don't mess with him down there. They took him out. That statement to the rest of them set the stage for the rest of the day. Questions then got answered that took a lot of time to get those questions answered, but we finally did get through that particular proceeding. The leaders, Mr. Skirdall specifically said that he would not let his people down. When he was making this speech, I started to think of Jonestown and Jim Jones with his cult-type leadership. And here were these people, and they acted like drones, sitting there going, oh yeah, he'll do everything for us. He won't let us down. And we went into a bail reduction type hearing. I had $25,000 bonds set on misdemeanors that were punishable with a $500 fine, 6 months in jail. But you couldn't get the people into court. They would post money and basically flip their nose at you right across the front of the documents, refuse for cause, UCC 3-501, et cetera, all through this whole thing. But Skirdall sat there, I will not let my people down. Guess what he did? He let his people down. The other 6 went to trial. He didn't. He went on the run. Went to Roundup, Montana, in the Bull Mountains, where he had a cabin. That's where they started to have their seminars where they trained all these people that are now out in all of your states and in Montana, plying their craft. Then they moved from there to what was commonly referred to as a compound in Jordan. It's not a if that was a compound, the whole state of Montana is an armed camp. It was a farmhouse, a couple of grain bins out there. They did not pick this place to defend. They picked this place to make a statement. I feel that they picked Garfield County due to the fact it's a very large, sparsely populated county. 2 law enforcement, 1 sheriff and an undersheriff. The sheriff's 26 years old, related to everybody. Everybody in the county is related to everybody. I mean, in some way or another. I think the federal government, when they got involved, thought, what are we going to lose? There's nothing there. I mean, they're there. Where are they going to go? They couldn't go north. There's a natural boundary there called Fort Peck Lake, so they couldn't escape going that way. There's one road that goes across eastern Montana or central Montana, Highway 200. We refer to it as Scenic Highway 200, and that's a joke. But responses from anything, law enforcement would have to come from long distances, medical facilities, Billings would be probably the close one, everything would have to be airlifted. So I think it was a strategy plan, and it was in a long time coming. He mentioned Gordon Call. Well, a couple years after that, there was Jerome Peterson in Circle, Montana, about halfway between where I live and there. The feds went in there. He was another income tax protester. In Garfield County, there was a couple named Burgers. The Fish and Game went in with a SWAT team and a CNN news crew to do a search on this place. And this is a gentleman that's 80 years old carrying an oxygen tank in his hand. I mean, he's not going to run away from you or present too much of a problem. And people took this as a serious assault on our rights. So I think it was a long time coming and planned. They will, again, intimidate you. They will threaten you. I was followed to and from court on Scenic Highway 200. Law enforcement couldn't give me any help. The federal government wasn't involved, but they, as I say, when they threaten you, they were going to come to my house and kill my wife and my children and I. So we had to take precautions for that. That was on several occasions. The thing that I can stress the most to you is train your judges on how to deal with it to begin with. Have a plan and work the plan. What I did is I was firm in my decisions. Whether I made mistakes, that will come out, I guess, in the future. Thank you.
Thank you, Judge Moore. What strikes me from what you were listening to you talk is that I could have been sitting in a conference room in Ohio hearing an Ohio judge talk and say virtually the same thing, with locations obviously different. I guess there is one other difference. I think all of our judges in Ohio have necks, but other than that, I think I'm interested in your statement, because it's been our experience so far that when they are brought to justice, I mean, when they are treated like everyone else, they do eventually back down. Well, they comply. And I'm wondering from Mike Reynolds, I sort of got the impression from what you were saying, particularly at the end of your presentation, that it's almost predestined that some bad things are going to happen from this group, and already have, of course, but that perhaps the more we push back, the harder they're going to push back on us. What is your impression of that? What would your advice be to us?
Is this thing working here? Just working? Yeah. Oh, thank you. I'm in agreement about drawing the line. And there are several reasons for that. One of them, let's just use tactics, is to marginalize those who will back down. Go, this isn't working. You know, they were along for the ride. It's not working. They have a future of some kind in front of them. Is to divide and marginalize this movement. There is an element of the movement that is not going to back down, is going to just go elsewhere. If they go to prison, they don't care. They're not going to go to prison for that long anyway. And they don't care. They achieve status. They conduct their affairs from prison. That's no problem. We're talking about hardcore, the hardcore folks. Schweitzer is going to do what he's going to do from now on anyway. However long he lives or he's in prison, he is still going to maintain influence on it. There was a statement earlier about the bank that settled. Let me give you something that happened that with Ford. I mentioned Ford Motor Company, and they had some liens down in Texas against them, and they settled. They settled to a pretty good penny. I suspect that there have been other corporations who said, look, let's just do this. Well, what happens with that is they take that settlement and they use that to bolster their case elsewhere, and has been used to bolster the sale of these liens. I'm really concerned about the amount of money this movement's generating that nobody knows where it is. The individuals to describe this hardcore. There are millions of dollars out there that have gone to something else besides lining pockets. I had the Treasury Department talking with someone at the IRS on the Hildebrand case in Iowa. They can only find $40,000 cash. These folks are living in trailer parks with old trucks. And they know they've generated millions of dollars. Now they can account for some of that with the Hildebrands putting it offshore and deciding about $1 million that they've got offshore, and they're planning to ride this thing out and get the hell out of the country and enjoy their money. But the rest of this crew, there's about $1.5 million that went somewhere that's doing something. And to me, the reason I'm mentioning that, when it comes to following the money, it's like we can all understand a scam that's meant for profit, to line somebody's pocket. But when this money, like Schweitzer's money, goes someplace and it's not lining anybody's pocket, and you have a movement that is extremely serious about affecting dramatic and possibly violent changes in the community, and they have millions of dollars out there, and they're not using it to build houses or buy boats or anything else, that is a major indicator that you're dealing with a very serious group of people who are willing to take this money and use it for the purposes of the movement. So the idea of marginalizing this section of the courts, taking these folks to task right up front, is, I think, a good idea at this point.
I think Chief Justice Zimmerman would like to respond or has a question.
Yeah, I have a question. What role do the courts have other than seeing that we don't, except for filing what are bogus liens? What role do we have in this lien business?
Well,
I mean, I understand that they're generating monies which may be used for illicit purposes. That's certainly a law enforcement issue. What issue is it for the judiciary?
One of the reasons that I was gratified to be here with Chief Justices, I think there has to be a leadership taken by the courts that is exercising an influence within jurisdiction and state regarding this movement within your state. I think by dismissing them or treating them just as any other citizens, I mean, we do that, but criminal organizations, these are criminal organizations, they're criminal conspiracies until they started treating them as a ongoing criminal conspiracy, and if you don't treat them that way, and you treat them just as a loosely organized bunch of upset citizens, I don't think we treat organized crime that way. I think it should be treated with it in mind that this is an ongoing criminal enterprise. That's where I think the judges should come to some understanding.
If I might address it too briefly, I know in certain states the appellate courts have taken a very dim view of the discretionary powers of local clerks and recorders. They've seen them simply as ministerial offices whose duty is to file whatever walks in the door with a filing fee. And fortunately, in Montana, our court has taken, I think, a more modern and compelling view of that office that with modern difficulties and training the clerks and recorders received, that they should have at least some discretion to refuse what's patently frivolous, what will simply not advance the purposes of the recording laws, but go counter those laws. And so I think that's one role that appellate courts in particular can see. Also in the issue of liens, I know Mr. Holland took on another one of his many businesses he was running was a lien filing service. And so in areas like Raval County, Montana, where the clerk and recorder wouldn't take liens, he was kind enough for I think $100 fee to you could send your lien to him in Boonville, Indiana, and he would file it in his lien filing service, and then inform the person that their lien was filed, and they go on about their business. And so he was making money hand over fist with all these different entities. When I issued the warrant for his arrest, I set the bail at $250,000, and he had that posted with one phone call. And he was later, when he was later brought to Montana, it was determined that the bond was only good within the state of Indiana. And so Judge Harkin, who then had the case, was ready to put him in jail, and with another phone call, he had another $250,000 lien. And when he came to Montana, he came in a private jet with private counsel that he retained in Nebraska. Money was simply not a problem for this man.
And I want to add something else. Joe Holland is not an aberration. There are others out there. There's some offshore. Grant McEwen, who's down in the Bahamas right now, fugitive. Holland is not an aberration. He's not a curiosity piece. There are others out there who are still operating, that are operating at Holland's level, who simply haven't been prosecuted or picked up, and they may not be, because they'll be gone by that time.
I guess it's the discussion here seems to me to raise an issue with which that's a difficult issue. One on one side, we are part of our responsibility. I think responsibility certainly is to maintain and indeed enhance our ability to resolve people's disputes in our society, and we work on that. The 25th conference in March, of course, dealt with the issues of accessibility and providing resources for people who can't afford lawyers, and opening the courts to people who have legitimate legal issues to bring to us. And it seems to me a complementary issue is that we not permit others who are attempting to chip away at the institution to do it in a way that consumes a tremendous amount of resources. The judge in Guernsey County to whom I referred, he spent hours and hours with a person whose motive was not to get justice, to be determined not guilty, but it was to thwart the system. Others had to wait for that to occur. They had to wait. Their cases had to wait, whatever it was, 2 or 3 days, whatever it may be. They had to wait. And I guess I think we need to factor that into maybe to Mike's suggestion that well, these are just people who want access to the courts. We have to give it to them. But if we see that their purpose in coming to the courts or their method in acting in the courts is so different than the rules for everyone else, and they affect everyone else, it seems to me that raises a little different issue for us. Mike, I'd like to ask you, there are some chiefs and administrators here, I'm sure, who are saying, I haven't seen the Freeman or the common law court movement in my state. Are they likely to come? Is this something that's going to be in all 50 states and the territories, or is the movement selecting states where they think they can make their best push?
I suspect they're in all 50 states now, to one degree or another, and depending on the configuration. You have to look at the common law court movement never went away. Posse comitatus never went away. This movement never went away. It just went through a slack period. Other things went on. In the 80s, there was a lot of publicity and so forth. These folks had just gotten older. They went to prison. They got out. They've raised another generation. The opportunity for this movement came up because of Weaver, Waco, Brady Bill, assault weapons ban, NAFTA-GATT, economic factors coming in. The conditions were right for it to all come back. The thing is in Kansas, Nebraska, Oklahoma, Missouri, Arkansas, the Dakotas, especially, that they hadn't gone anywhere. They just came back, and they had the technology to. The difference is technology, personal communications technology, has spread it around the world. We're talking about, you go to something on the internet. There's something called Homelands, and it's all Homelands page has the Bosnian Serbs, they've got Greeks, they've got our sovereigns. It's a separatist movement here. They all can go there and share their information on their nationalist separatist movements. Sovereignty. These ideas are being shared with groups around the world. I mean, it's not 50 states. This is something around the world. I can't imagine. I don't see one state bereft of a common law court. It's just that the intensity is higher in some areas than it is in others. But sooner or later, it's going to come up somewhere in your state. You're not free of it. You're not free in the District of Columbia either.
Thank you. It's 20 minutes to 11. Unless any of the panelists have another point they'd like to make or question you want to ask of each other, we'll move to questions.
I just have one question, and this would be, I guess, to all of you, maybe starting with Ms. Hanson, is do you think the publicity is good or bad for these people? In other words, engaging them publicly in dialogue about their premises?
I think it's a double-edged thing. I mean, on the one hand, when you spend time with them, it seems like some of them are acting out some kind of rebellion, and the attention it is something that they want, and I think it makes them feel like they're legitimate. But on the other hand, I mean, without calling attention to it, it just seems like they're going to organize more, and it's going to get bigger and more destructive. I mean, I talked to one sheriff in Colorado who said he was actually head of the Colorado County Sheriff's Association. I mean, I talked to one sheriff in Colorado who said he was actually head of the Colorado County Sheriff's Association and said that he thinks in certain counties that there's a real breakdown almost in the justice system just because these are sparsely populated places and sheriffs can't control them and they're just openly flouting authority. So I just think you can't let that kind of thing go on.
The thing about publicity is they don't need and they don't trust what I refer to as the straight media, national or local media. They have their own media. They don't need the New York Times. They don't need NBC. They don't need any of this. They're already well connected. So as far as media, as journalists reporting on this, I think it does more good because it gets the opposite side out. Because there is a counter to what they're saying in the press. They say something, it can be countered in the press. And they deal in a closed system. They have a closed system of media that is great. They cover all the angles. All they do is listen to shortwave radio. They go to the internet. They read those publications. It is a self-supporting closed system. They don't need the lies of the New World Order controlled media elite or Jewish occupied government. They don't care. They absolutely don't care. So as long as I think the media as reports should get out there and it should be countered. Whatever they're saying should be countered in the press.
Questions or comments from any of you? Yes. Chief Justice Benham.
about that is this one comment. I noticed especially with Southern property law, we were very successful with trying to follow the money trail and dealing with that. I wonder if you would be effective in dealing with this type of. The reason I mention that is my hope just got to see prior to coming up. Even more interesting, when I turned it over to all of them, they are remarked, well, this is just what we do. And I think that's how law enforcement is looking at it. We do have tools available to use with economic tools that we're using in the drug war also. Will that be effective in any way with this organization? And if so, what roles should they be playing in encouraging law enforcement to turn them to these?
Well, we are looking at when you refer to the Klan in those days, they were loud enough. They were like a big ugly carnival truck coming down the street. I mean, they were, as far as their money went, they didn't see this coming. One of the things that has happened partially because of the success the Southern Poverty Law Center had against the Klan, against White Aryan resistance, in the Metzger case in '89. Companies. So we're looking at strategies that are much more sophisticated now, and consequently we're looking, as far as SPLC is concerned, some other avenues than vicarious liability. But to get to what you're saying about the law enforcement, one thing that is needed that is very important is the sharing of intelligence as far as law enforcement. As far as the support is concerned of the Chief Justices in this matter, an intelligence network needs to be set up out of the states rather than out of Washington, D.C. down. The best intelligence available concerning this or any other kind of terrorist or insurgency network is really coming off the ground by the states. And there needs to be a network of that, rather than looking to Washington, D.C. and looking to federal law enforcement to come in and take care of business, because they don't know what these gentlemen know. There's no way. These men have had the experience and are an asset in this. And elsewhere in the country, there are other officers of the court and in law enforcement who have a wealth of information on this movement, because they've come into it face to face and they've taken the time and trouble to get into it to understand it. So as far as law enforcement, what the Chief Justices can do and the courts can do, along with taking strategies to blunt the problems, is to take a leadership role within the states as far as seeing to it that some strategies are developed in law enforcement and in legislation and in the courts to deal with this problem and see it as a serious problem.
Directly.
Well, as far as the common law court, it was as it was explained to me in one of the meetings out in the field with them, just this last April down in southern Missouri. Spiritual warfare was the thing. Bible, they view the Bible not as a spiritual guide, but as a book of governance. They'll hold the Bible up and say, "This is the law. This is the government." What's been portrayed, statements and so forth, that this is an anti-government movement. It is not an anti-government movement. They intend to have a government. And they see establishing, part of the strategy of this is establishing the court is establishing authority for any actions beyond that. This is the law. They see the law as one thing. They say the legal system is another. That's created by man. The law is above it. What they propose is above it. This is the form of governance. So it's not just judicial. At the hardcore of this movement, it's not judicial. It's the establishment of authority. So legislative-wise, they're not interested in democracy.
Just go.
What happened was they set up what they called a constitutional court and advertised and ran a legal business. People went there with dissolutions of marriage and filing them. But granted, the course of the decreasing court, this court decided child custody, and they had a railroad business. The issue was assumption, stop, citing consent, and reply immediately to them about two of them, and in jail those two. So this is just another extension of what happens from the back. We have an innocent folk right there thinking I'm getting a dissolution of marriage. This court is solving my child custody problem, and wasn't at all.
If they'd read Susan's article, or perhaps an article in the daily newspaper, they may not have gone. You make a point that I think needs to be made again. Public information is critically important. Yes,
I might mention, I'm not sure about Florida, but there are at least a few states now that have a crime known as simulated judicial process. I think Wisconsin is one. There are others. To attempt to criminalize something like that, which really takes advantage of the ignorance of certain members of the public and frauds them in the name of justice, I think there's no better definition of crime.
Yes.
They were pretty hospitable for the most part. I mean, I would say most of them were interested in talking. There were a few that were very wary, and I did feel a little bit uncomfortable at times. But I mean, for the most part, I didn't have a problem, and they were very open in talking to me and trying to explain what they were all about.
Yes, wait. Next. I can respond and give you a partial answer from our experience in Ohio. Is that one of the persons who has been the most help to us and a vigorous opponent of the movement is an officer of the Columbus Police Department who has become the funnel in the state for information. This is his full-time job now, is to know what the common law court movement is doing and share the information. I think generally law enforcement sees this group as having targeted them, law enforcement, because they're the ones that serve the citation, that pull the person over when they're drunk driving or don't have a license tag or whatever. There are certainly fringes there. I would agree that intuitively you'd think there might be some people in law enforcement who would be sympathetic or at least empathetic to the movement, and I certainly wouldn't deny that. But generally, again, our experience in Ohio, where there's a lot of activity, is that law enforcement is very, very strongly opposed to them. Mike, you may have.
Yes, just for every There are the movement has recruited law enforcement and the military and prison. Those are the three targets that have come out of the racist right and moved into especially Christian identity, and with it common law and so forth. But there are officers, sworn officers, who are involved in the movement, who have access to NCIC and use it for screening. They do training for the marshals of the common law courts. These training sessions are conducted in Oklahoma. There are officers who are on the Patriot Common Law stump. Jack McLam, who has Aid and Abet, which is a part of this movement against the New World Order, and an advocate of common law, police officer. His publication targets law enforcement. There are far too many law enforcement officers at the local, state, and unfortunately, there are some within the federal law enforcement that have been sympathetic as well and provided information.
Yeah, I just wanted to say, at the common law court in Dallas, there was a police officer from Orlando who was there attending the court, and at the training seminar I was at, there was a sheriff from Arizona who actually spoke to the whole group. Oh, and also recently in New York City, there were a group of police officers who were indicted for evasion of income taxes, and one detective, he identified himself as a citizen of the Republic of New York. So I think that they're definitely, yeah.
Chief.
I haven't seen any here. I was wondering if we could rely on the design of the hotel that was
Surely anyone who tried something here would be caught before they got out of this building. I can assure you that without we're being taped, without being extensive about it, there is security here, and the staff believes that it is adequate under the circumstances. Andy.
They, according to the information we have on those actions, that these startup banks are, in some cases, purchasing these in good faith so that they have assets that they could then go and do business with. All right. So we have $20 billion in assets, and it's not confined. They're not relying just on that to build up their bank, certainly, but others as well. Now, unfortunately, what they're using is they've got part of their foundation built on a house of cards. One of the intents, which is we're exploring besides the money, which is very interesting, some statements that came out of individuals in the movement who are involved, who know about this scheme, this production, that they know who owns some of these banks. There was information, I can relate to you an anecdotal one, that was said, such and such Japanese multinational owns a couple of these banks. And it was advised to watch them in the market and go ahead and sell appropriately, because these banks are going to fold. Now, that's not financial advisement coming out of the movement. And one of the intents of some of the counterfeiting that was done out of common law, James Wickstrom, was involved in counterfeiting. The idea of counterfeiting is to undermine the economy. I mean, there are tacticians in this movement who are the old liners, who are the sources of Ippolito and Magdad, who had the Constitutional Court. They got their information out of this. They got it out of the identity posse common law. And then they took that and said, hey, we're going to set up business, and did. But then McEwen, who's out, you're familiar with Grant McEwen, who's offshore right now, he was involved with Landers and some others in North Carolina, and with others who are still operating with militias and common law courts in Florida, who are coming out of this movement, who are real hardliners. Magdad and Ippolito, they took that and then built something for their own business, essentially, on that, rather than coming out of the heart.
Alma Wilson, did you have a...
Well, based on what you're saying, I'm assuming a friend of the movement, perhaps could be holding political office in Oklahoma, correct? Individual that holds political office in Oklahoma is bringing forth. This is a friend of the movement who says he's gone to the legislature. He can get no help there, and so he would like the Supreme Court to operate as a forum for a legitimate discussion. Bad idea right off the bat. Inviting them in and legitimizing anything that they will simply use that. They will simply use that as for propaganda purposes and for some legal purposes later down the road. Their grievances. You touched on something though about their grievances. 98% of it was what? BS, and 2% was good. The important thing about this, the grievances, like everything else, in this world, in knowing troubles and disruption and madness, is that there is a kernel of truth there. There is some reason. Tens of thousands, millions of people, at least interested in approaching parts of this movement, would not be doing so unless they had a reason. And as the old playwright said, that tragedy is knowing that everyone has their reasons. So these grievances, I just want to touch on that and not leave this as a view of these folks. They do have their grievances and their hurts and their pain that haven't been addressed. But as far as bringing them into the Supreme Court, no. I mean, that's some other panelists may have a different opinion, but I'd say no on first blush. No.
One last question from Rob Baldwin, and then we'll break.
That's already been done. It's been done within the U.S. Taxpayers Party. In Wisconsin, the anti-abortion extremists, we're talking about those who advocate justifiable violence, even murder, who have long have preached tax resistance, don't pay taxes. Matt Trujillo is somebody I think of. But in Wisconsin, there are common law courts there that are specifically targeting pro-choice supporters. I believe it's the sister of the Wisconsin Attorney General, as Catherine Doyle, is dealing with the problem right now. But this coalition's already been formed. Identity is moving out of the heartland and out of its racist trappings, and already has moved into coalition with Christian Reconstructionists, such as an example of Christian Reconstructionist Randall Terry, Matt Trujillo, out of Operation Rescue, and there are others out of the extreme Christian, self-professed Christian right that seek to establish their own form of governance. So that's all. The groundwork's already been laid for that. They are going to be looking for political office and are already working and moving people into political office as best as they can for the last couple of years, and there will be an increase of that. So the answer to your question is yes. And some of the extreme baggage and the most extreme will be underground, and will be conducting terrorist and insurgency actions underground. They already have. The others will have to move on in their particular locale to gain power as best as they can legitimately.
With that happy conclusion, it seems that we need probably more than coffee and tea, but that's all we have, and soda. We'll be back in 15 minutes. I'm going to ask the panelists to stay, if you can, until after.
Me to remind you that your picture box lunch is it over by the office? It's over by the registration office, just across the mezzanine. It'll be available right after session. Several of you asked for copies of the videotape that we played yesterday, the one that was in this room on the sort of vision of the future of a judge speaking to a computer and so on. We were able to get a dozen or so made, and we hope to have those tomorrow to hand out to anybody who wants those. Someone asked me to remind you that at your place, Susan Koenig, who was not able to be here, but she did provide each of us a copy of an unpublished manuscript. She's making that available to you, and she sends her regrets because of some family emergency. She wasn't able to join the panel this morning. Finally, before we introduce our final speaker, you know, when we put these things together, there's a lot of people behind the scenes that do a lot of work, and I wanted to take an opportunity to thank and recognize Frank Gavin, who's helped put all the panels and speakers together, working with the various conferences and education chairs to make the program happen. And also Shelley and Brenda, who in the back, who do all the registration, send you all the materials, and make sure everything goes so smoothly. And hopefully you'll join me in thanking them with a round of applause for their work. And I'm sure there's many others in the National Center that should be thanked, and I hope at some point we recognize the great job that the Tennessee staff have done and all that they've done for us. Let me introduce our final speaker. I was in the back of the room kind of pacing around because I thought our final speaker was AWOL. In fact, I actually thought he wouldn't appear given the events that the TWA flight and the events going on down at the Olympics. I thought he might have some other duties. But I was about ready to give up, and I realized I saw someone in the back of the room who I didn't recognize. I went up and asked if he was Jim Reynolds, and sure enough, he had already infiltrated our group and had been sitting there for the entire session. It's my great pleasure to be able to introduce the head of the Department of Justice, the chief of the Terrorism and Violent Crime section of the U.S. Department of Justice, Jim Reynolds. Jim has held a number of posts with the Department of Justice, has had experience in dealing with international terrorism cases, domestic violence, property offenses, regulatory offenses, and so forth. Previously, he was a captain in the Army, served in the Judge Advocates Corps. His law degree is from Cornell University. And the mission we gave him today was to now that we scared the hell out of everybody, we wanted to at least let you go away with a few practical things that you can do if you're confronted with some of these problems. So let me turn it over to Jim Reynolds.
Good morning. It's my pleasure to be with you this morning. I don't know how practical suggestions are that come out of Washington, but I can tell you that the reason I was in here this morning was my objective in making this trip really is to learn more than to impart knowledge. I think that Michael is right on in the statement that information flows from the field, and certainly you all are at the forefront of seeing what the common law court movement can impact, how it impacts on courts. So I'm here this morning to learn. I'm here this morning to see whether there's something in the federal arsenal that can help address this problem. And lastly, I'm here to set up what I hope will be a continuing channel of communication so that it's not on a once-a-year conference that we talk, but to the extent that you have an issue or concern that relates to federal law enforcement, there is an established means of bringing it to our attention, and so also we have a continuing way of learning from you. For the past about 13, 14 months, I have chaired what we call a domestic terrorism working group at headquarters of the Department of Justice. It's comprised of representatives from not only the Criminal Division, but also Civil Rights Division, Environment and Natural Resources Division, Tax Division. U.S. attorneys have a representative. The FBI has a representative. And the purpose is to attempt to get an overview as to what's going on in the field. We have 94 U.S. attorneys' offices, as you well know, throughout the country. Those U.S. attorneys or the first assistant in those U.S. attorneys' offices certainly has a good sense of what's going on in their district. But what they may not have is a sense of how the problems they're encountering in their district interrelate with the problems being encountered in other districts. So this is an attempt to cross district lines and to get a better sense of what the national picture is. And additionally, the purpose is to address cross-cutting type issues so that we don't have issues that arise in the civil rights area that aren't shared with those of us that do terrorism or traditional violent crime. Now, one of the ways in which we attempt to carry out our work on this group is that we receive monthly reports from each of the 94 U.S. attorneys concerning every domestic terrorism investigation or prosecution that's pending in their office. And we define domestic terrorism fairly broadly so that we pick up not only your traditional violent crime, which is undertaken to achieve a political or social objective, but we also pick up fraud-type violations or violations of violent crime violations that are designed to finance domestic terrorism activity. So Freeman-type offenses are reported in through this system. We analyze the data. We discuss what the federal government should be doing that it isn't doing. Let me just say, as relates to common law courts, that from these reports we have 26 districts of the 94 that are reporting that they currently have an investigation underway or a prosecution relating to common law court activity. And I am separating out right now the Freeman cases. I'm excluding from that the Freeman cases. I'm also excluding cases that we tend to catalog a little differently, but there's cataloging isn't really the critical thing. But the Viper militia case, the Georgia militia case, the arrest last Saturday night in the state of Washington, people that are building destructive devices, those I'm not categorizing in the 26 districts. Now, a couple of the common law court activities have led to federal cases that let me just mention briefly, and they give some example of what we're seeing. First, everybody knows about the Freeman case. I mean, it was national publicity for a significant period of time. The Freeman scam is really a little hard to get your hands on. and I don't think I'm going to try to define it in great detail any more than Michael did, but just reading from one of the Freeman newsletters from July of '95, we have used our credit established under UCC liens placed on a number of delinquent public hirelings who have refused to follow the rules of their own codes to pay off farm foreclosures, IRS liens, and judgments. So it's pretty clear. There's nothing too secretive or clever about what they have in mind. They're going to file liens, and they're going to try to draw credit off those liens. Now, the task of defining how this lien system works, I took some comfort in a district court decision out of this is Eastern District of Washington, a suit brought to extinguish liens. The plaintiff sought to have the liens dissolved, prevailed in U.S. District Court, and when it came to that part of the judge's memorandum of opinion where he was going to describe this lien system, he says, according to the plaintiff's, quote, a reasoned analysis attacking the basis of the defendant's liens is impossible because the rationale supporting the liens is absurd, end quote. This is true, said the court. These, quote, consensual commercial liens, end quote, together with accompanying materials are unintelligible. Quote, it is a task of no slight difficulty to draw from these documents a cognizable legal basis for the liens. And he cites to a 10th Circuit case. There's no legal basis for filing these common law liens, complaints, and commercial notices. Every court to consider the validity of these documents has found them to be without basis. So to try to ascribe some rational sense to what this scam is about is at best very difficult. But in its simplest form, reduced to its simplest form, a demand is made, a lien is filed with a recorder's office. Normally or oftentimes a checking account is open, maybe with a $100 deposit. The lien is then deposited to that checking account, and checks begin to be drawn on the checking accounts, and the checks are for astronomical amounts. So far, and Michael's figures may well be right, but the figures we have are those that we are aware of in the federal system. We are aware of slightly over 1,300 Freeman checks. They have been circulated in almost every state in the United States. The checks that we're aware of have a face value exceeding $750 billion. Our sense is that that is just the tip of the iceberg. There are a lot more checks out there. The losses from these checks total slightly over, again, of the ones we were aware of, total slightly over $1.8 million. These checks have been negotiated successfully at private businesses. Automobile dealerships have been particularly victimized. Financial institutions have been victimized, and the IRS has accepted 4 of these and has losses totaling $29,000. They assure me that they have rectified their problem. This was part of the quick refund. You send in your return and you get a quick refund. And what was happening here was checks were being sent in by Freeman-type checks were being sent in for more than the amount owed, and the IRS system was very quickly kicking out the requested refund. They've learned their lesson. Freeman investigations at this point are pending in approximately 50 of the 94 districts. There are prosecutions ongoing in 6 of the districts, and of course, most publicly known, the District of Montana. Let me shift gears from the Freeman to a different kind of situation, and one that you may encounter more typically in the court system as judges and as court administrators. This case involves an individual named Jerome Schiffen out of South Dakota. He was the subject of a federal foreclosure action, and so Mr. Schiffen's response to it was to do a couple things. First, he did his own foreclosure action on the judge's home. He sent the judge a letter that is a little bit difficult, but it's understandable. And a portion of it says, you're attempting to sell property in which you have no authority to do so and are violating the actions of our one Supreme Court, a higher court. You have forced me to quiet title on your property as I have a lien on this property, and I will proceed to sell the property. I am sending you a motion to strike and reverse your order. I'm skipping down through the letter. If this is granted, I will not sell your property. I would be willing to meet with you in an effort to release the lien on your property. And then he closes with a sort of cute postscript at the bottom that says, this letter is not to be considered a threat or an attempt to delay or hinder due process or constitutional law. This is not a bribe, just a good faith offer of settlement. The other thing Mr. Schiffen did in short order thereafter was to file with the judge a public notice of treason, which advised the judge, among other things, that the penalty for treason was death, and then Schiffen attached to that his own. The notice of treason is a form that you all have probably seen. It's widely circulated. Schiffen then attached to it his own typed statement, which says, in effect, any action that shall be taken to enforce this treason ruling shall be any action taken by the court, shall be considered treason. And out of the law of necessity, I, Jerome Theodore Schiffen, will do as stated in Beauvoir's Law Dictionary, quote, whatever is done through necessity is done without intention, and the agent is not legally responsible. The above-named people do know or should know that the punishment for treason is after a finding by what it is after a finding by the Supreme Court, which of course is death. At that point, Mr. Schiffen was arrested for obstruction of justice, for attempting to obstruct the foreclosure case, and for also threatening a federal judge. He went to trial in early July, was convicted on July 10th of both counts. There is sort of interesting postscript to this case in that while the case was pending, the common law court with which he was associated issued a habeas corpus order, which they sent to the jailer who was holding Schiffen. It ordered that Schiffen be produced on a certain date for a habeas corpus hearing in the common law court. They also served on the United States Attorney, or prepared for service on the United States Attorney, a summons that she would appear at that hearing. Miraculously enough, that summons was served on her by the local sheriff's office. How that happened is not quite clear, although they do, as you've seen, tend to phony up documents that somehow have an appearance of reality. The habeas corpus hearing did not occur. From just those two examples, but going through the rest of the common law court-type cases that we have seen, you can break them out in several areas, and you'll see these are really sort of a continuum from the light end to the end that becomes an increasing concern to you all and a concern in my business. The first category is the flat-out scam, the money-raising operation, and certainly we have seen those. The second category is the harassment, the Schiffen-type activity of harassing someone, either because they're taking some action against the common law court member or for whatever the perceived reason is. The third type of activity is the threatening activity. Again, Schiffen crosses over there with his notice of treason. And then the last is the assaultive type of activity. And there is a continuum there that is a concern. Most of what we're seeing is not violent activity. Some have referred to it as paper terrorism, and maybe that's right. But the killing of Officer Motley in Opelika, Alabama, that was mentioned earlier certainly reflects that there is a potential for violence, and that potential we take very seriously. And I'll talk about that a little bit more. Let me talk to you about the federal constraints on investigation and what the federal laws are that may be relevant to this area. First of all, the FBI functions under what are referred to as Attorney General guidelines. These guidelines have been in one form or another in place for 2 decades. They come out of the FBI excesses of the early and mid-1970s and the view by the Department of Justice that something needed to be done to more tightly control federal investigative activity to ensure that the rights of private individuals were not violated. These guidelines attempt then to strike the appropriate constitutional balance, and hopefully we do that in those guidelines, but they provide that the Bureau may not undertake an investigation unless they have reasonable indication that a federal criminal violation has been, is being, or will be committed. In other words, their investigative activity has got to be tied to an a federal criminal violation. Now, there are provisions for brief inquiries where the factual information is less than necessary to establish that reasonable indication. We have what we call preliminary inquiries. They can only run for a limited period of time, and only limited techniques can be used. And at the end of that preliminary inquiry, the basis either would have been developed to move into a full investigation, the reasonable indication would have been developed, or else the inquiry is shut down. So the Bureau functions under those guidelines. They also function under Privacy Act law and guidelines, which say that they may not, we may not, maintain materials in our files that have no relationship to appropriate criminal investigative activity. So when the FBI creates files now, those files must be tied to either a criminal investigation or a preliminary inquiry. And in fact, under the Privacy Act and the rules that the FBI functions under, if they gain public source material, before it's placed in an FBI file, they must identify on it, so it'll be preserved in the files, what the investigation or preliminary inquiry was that gave the basis for the preservation of the public source material. It is something that at times can be frustrating to live under the guidelines, but they are obvious a good faith attempt to balance effective law enforcement with excessive law enforcement intrusion on law-abiding citizens. As relates to those guidelines, in November, we did circulate to all FBI offices what we referred to as an advice, which was to say to them that in some field offices it was our belief that the Attorney General guidelines had begun to be construed too narrowly, too defensively, and I say that without any criticism. It's the FBI agents that tend to get sued for excessive investigative activity, not those of us that are prosecutors. But what we tried to do in that advice was to provide some practical guidance as to what was intended by the FBI guidelines so that appropriate investigative activity in the domestic terrorism area can go forward. Building on that, let me switch now to the issue of what the federal criminal violations are that are pertinent to common law court harassment or other action that's been taken. And you'll see that just as the federal criminal justice system is a limited system, our statutes are limited in the basis that they provide for responding. They are not comprehensive. And I just tried to break them down as to what the jurisdictional basis was of the particular statutes, and trying to break them down by the nature of the victim. We have statutes that are based on the federal nature of the victim. Okay, and these you're going to see very quickly aren't going to help the state courts or the state court administrators a whole lot. But federal jurisdiction, what is federal jurisdiction? Federal jurisdiction in the criminal area is where there is some federal interest to be preserved, or there is an interstate commerce nexus, or some other appropriately recognized federal basis for jurisdiction. So the first group of crimes you have relates to the federal nature of the victim. So you've got crimes. It's a crime to threaten to assault a federal employee if that threat is done for the purpose of impeding their action. It is a crime to impede, oppose, resist a federal employee, but that statute is very limited as it relates to most federal employees because it requires that the opposing, impeding, resisting be forcible. So it is essentially an assault statute. It's a crime to conspire to impede by intimidation federal employees. And lastly, and this is the best statute, although unfortunately least broad in its reach, for Treasury employees, there is a statute that makes it a crime to corruptly endeavor to impede their operation. That is a statute that in the common law court area, we may well think about trying to extend to cover all federal employees because it is, in scope of its coverage, the best statute, but right now only applies to Treasury agencies. Also looking at the nature of the victim, the federal nature of the victim, but moving away from people. It's a crime to obstruct federal proceedings. So federal court proceedings obstructed in the Schiffen case. Schiffen was indicted for the obstruction as well as the threat on the judge. It's a crime to take action relating to federal entities, mail fraud. So in the pending indictment in the Freeman case, there are a load of mail fraud counts. Banks, since there's federal insurance. There is a bank fraud statute. Again, in the Freeman case, there are a lot of bank fraud statutes. Now, all of that tends to look, at least the bulk of those tend to look inward to the federal system. The only statutes of more general application that may be of benefit in your situation may be the mail fraud statute. There are also statutes that are tied to interstate commerce. It's a crime to mail a threatening communication. And that mail need not cross a state line because of the involvement of the U.S. postal system. It's also a crime to communicate interstate, a threat. But there, that threat must actually go across a state line. It is also a crime to use the telephone to make a threat, but except for bomb threats, the telephone threats of any other nature than the bomb threat must go across a state line. So those are your basic interstate statutes. And the reason that those are important to us is that they trigger the right of the FBI to investigate a violation. Now, what I haven't covered in there is we have a whole host of statutes that relate to situations that hopefully you're never going to have to confront. Somebody builds a destructive device. There's a federal statute by which we can address that destructive device. They blow up a building that affects interstate commerce. We can respond. But the end of the federal statutes, it's more pertinent to the harassment that you may be subject to, has substantial limitations, at least right now. And that's one of the issues that I certainly will think about and that those of you here may think about within the constitutional parameters. To what extent is there a basis for federal legislation that may permit, in appropriate cases, a broader federal response? As it relates to common law courts, my sense is that we have, at least, and when I say we, I'm talking now the federal system, we have allowed the people that are involved in common law courts to become emboldened. And that has come about in two ways. One is the federal system tends to be a big, unwieldy system. And when you are talking the kind of conduct that is involved with the common law courts, there is a tendency of the federal law enforcement apparatus not to move into the area quickly. The other aspect of it is on the Freeman fraud system, there was a knowing decision for pertinent strategy reasons not to move forward with Freeman fraud cases in other districts until the Freeman standoff in Montana was resolved. And there were good legal bases for doing that that relate to discovery obligations in court. So what happened was you developed a very substantial backlog of federal fraud cases that were investigated, were ready to be filed, but were not filed pending the resolution in Montana. So you are seeing now a significant number of cases being brought, a significant number of arrests, and hopefully flowing from that a degree of deterrence. As relates to where from here, in my business, the violent crime business, but particularly the terrorism business, the highest calling is preventing crime, protecting people by preventing crime, and it's perhaps most graphically understood in terms of weapons of mass destruction or potential chemical, biological, or nuclear weapons. I mean, you literally can have a disaster if the act is not prevented. So we believe very firmly that the first responsibility is to try to prevent violent activity. When you look at the Freeman, you say, well, it was. You may say, well, it was a fraud scam, and that's true. But remember, we talked about the continuum of fraud, harassment, leading through to assault. That there is the potential of assault, and if the potential is not there in the Freeman, one only need ask themselves, why did the FBI stay on the perimeter for all those days? Why didn't they just walk in and make an arrest? There is at least reason to believe there is potential danger in this area. I can tell you also that when Jerome Schiefen was arrested, substantial planning over a period of time went into that arrest to ensure that the arrest was done in a way that was consistent with the safety of innocent bystanders, the safety of federal law enforcement, and also the safety of Mr. Schiefen. So there is the potential danger. We are acutely aware of it. We want to avoid it. We would like to reach out to you, and to the extent that we have a role to play that cuts this off before it gets to the danger point, we would like to play that role. My sense at this point that the danger is the greatest when the common law court individual feels that they are in a defensive posture, when the foreclosure is occurring, when the arrest is about to occur, when the policeman approaches the car in Opelika, Alabama. That's the point at which the danger is the greatest. My sense is to be a little more optimistic than the keynote speaker. We've been through a lot of problems in the 25 years I've been in this business, and most of them have passed, and this one will pass too. But we would like to work with you to do everything we can to ensure that the passage of this problem that we face, that you face even more directly, that passage is accomplished as quickly as it can be accomplished. As I said when I started, really my purpose in being here was to sit through the earlier session, to hear from your keynote speaker, to hear from your panel, to learn, to establish a line of communication that we will continue. So at this point, I will stop, but I would certainly welcome any questions, comments by anyone in the audience or any of the other panelists. Thank you.
We have a few minutes left. Why don't we see if we have questions for Reynolds or other members of the panel? Any questions? Yes, Judge.
Mr. Reynolds, I heard you.
Jim Reynolds? This Reynolds?
Yeah. I heard you correctly. Known terrorist groups, unless there's something of an immediacy, an ongoing justification, an ongoing investigation. If the FBI can't, if who in the United States is doing it, you say, well,
Yeah, let me address that and brush aside quickly the international terrorism area, where obviously, as it relates to activity of people outside this country, the rules on intelligence gathering are entirely different, and the retention of the intelligence entirely different. And there's been significant success in preventing international terrorist acts directed at the United States. As it relates to activity of Americans in this country, the guidelines are, you correctly described, designed to sharply limit the development of intelligence information. There is a basis for limited intelligence in the domestic terrorism area. There is a specific, the guidelines are divided into a general crime section and then a section on racketeering organizations and domestic security / terrorism organizations. In that latter area, there is a basis for the conduct of an intelligence investigation. However, it may not be started until that same threshold of reasonable indication that a federal criminal violation has been, is being, or will be committed has been reached. And in fact, under the domestic terrorism part of the guidelines, there's one other factor. The predicate criminal violation must be a violation of violence. Once that is met, there is a procedure that is sharply monitored whereby an intelligence investigation can be begun. The only real difference between the intelligence investigation and a normal criminal investigation is that in the intelligence investigation, the Bureau is permitted to carry that investigation on and to continue to develop information without necessarily moving to bring the investigation down when they could obtain an indictment and prosecute people. They can look more broadly at the group that's involved. But again, the starting part of it must be a nexus to a federal criminal violation. Sure.
Certainly.
No. If the investigation was appropriately undertaken, the file stays. The file is not purged.
Right in the back.
Other than the out of curiosity as to whether you have to have any women involved. For those of us that live a one-paycheck a month, it seems rather interesting to know that there's a market for what appears to be on the face invalid documents of debt or lien. One, how does that market develop? Two, is there any benefit work taking place on the international scene to give out warning letters or anything through the Department of State or anything of that nature to cut out that revenue source of selling these liens to third world banks or emerging banks?
Let me give you a narrow answer, and Michael might be able to give you a broader answer. Within the United States, there has been a warning to banks by the Federal Reserve System to be on the lookout for these things. I did not bring copies of these checks along, but if you look at these, if you go back 2 or 3 years, they were almost laughable in their appearance. They aren't now. I mean, they look like the real thing with the computer coding on them. And it's not too hard to see how people get sucked in, save one thing. If you look at the checks that we're aware of in the Freeman scheme, those 1,300 and some checks with the $750 billion amount, the average amount, face amount of those checks is over $500,000. Now, I'm just a guy that gets a paycheck every couple weeks myself. I don't see a lot of checks that average $600,000. So that's a payoff that's a telltale sign for those that are receiving these. But apparently, when you're talking businesses, then that may not be an unusual tip-off that you've got the problem.
Mike Reynolds, do you have anything to add to the question about the international market? Is anything being done to try and shut down the actual marketing of these?
There's no indication right now that where these individuals are operating, how they're operating, and also to understand that that isn't the only thing some of these brokers do. They have other operations as well. They have other dealings as well. It may be, and I don't know, Jim may know more about that too, that there would be an avenue with some of these individuals regarding drug laundering, some early information not confirmed that some of these individuals may have relationships in South and Central America involving some banking enterprises that are part of drug laundering. And that's a whole different operation, and it may be an opportunity to look into these operations. I don't know.
Yes.
There are a number of very broad if you read the really did not mention this.
RICO is a very broad statute, and to the extent that you get a very broad conspiracy, it certainly could be used, because you're right, a state extortion violation is a predicate under RICO, and the federal mail fraud statute is a predicate under RICO, so it does have potential. The Travel Act, I don't perceive to have much potential. I mean, that travel has got to be done for carrying out a limited type of crime, such as an arson. So I'm not sure that we are going to have much application there. Hobbs, I don't know. I mean, Hobbs is certainly something that we looked at before we got the FACE statute in the abortion violence area. Hobbs was our bread and butter statute for reaching abortion violence activity. I don't think it's well situated to reach activity undertaken against a court, a state court, but I certainly wouldn't rule it out. We would have no hesitation in going that direction if it seemed indicated. My sense of these people is that not only do they not get along with most normal law-abiding folks in our society, but they don't necessarily get along real well with each other. And so what at least I've seen so far, and this, a month from now it may be different, but what I've seen so far is little pockets of activity with the common law courts, not an association of common law courts in 50 states or even throughout a single state. Absolutely, it can. But there also is a time when because you have a whole lot of widgets that are accumulated together, you have nationally a problem of great significance. But when in the court system you have to approach it a widget at a time, the use of RICO may be firing a cannon at a gnat. But your point's well taken, that technically the jurisdiction is there, and we would not hesitate to use it if it looked like the right way to go. I mean, prosecutors are going to use whatever is the best vehicle to accomplish the end.
We have a question over here.
Yeah, I would like to say something about that. From our experience and work over the last several years, that these common law courts are not isolated. State House arrived in North Carolina, where he went to a common law court in Rightous, North Carolina, filed papers on the judge, the state attorney, the deputies in Colorado at this common law court, had them served in Colorado. Meanwhile, he and Dana Dudley leave North Carolina, travel through a safe house network to Montana. Meanwhile, they file papers in Queens County in New York on weapons charges. It would be naive to see this movement in little isolated pockets at this point. I would be in disagreement with Mr. Reynolds right now.
And let me say this. I read a lot of material put out by Michael Reynolds' organization. We learn from that organization, and he may well be right, and a month from now I may be in full agreement. I mean, that's part of what we're doing is educating ourselves. What I speak to as relates to the isolation is simply what I've observed to this point.
George.
My question is whether or not your office will underwrite the cost at the state level for holding seminars, or whether or not you will make grants available to the state, so that we don't have to tap into our limited resources.
Well, that answer is easy from my office. I have a hard enough time getting resources from my own office. I have no grants to give out. But the Department of Justice is a sizable organization. There are components that are not involved in criminal prosecution, such as the Office of Policy Development and the Office of Justice Programs. And it's possible that there is some grant money. I just don't know. I mean, that's out of my area. But I'll be happy to put you in contact with people that can give you a definitive answer.
I will mention that Dick Van Dusen's in the back of the room, has been taking notes, and I think, as I recall, at their lunch meeting from SGI on Monday, they asked for suggestions on priorities for their funding coming up in November. Or when is it, Dick? So perhaps if this is an area of interest to chiefs and court administrators, we should let SGI know, because at least that's one granting authority we do have some access to. We probably have time for maybe one question more if we have one. Yes.
Yeah. Doesn't make sense, does it? But that's what they're doing. The bank's not honoring the checks, but that's what they're doing. No.
Any closing comments or points from any of the panelists?
I'd like to thank the panelists and thank Jim for your participation.
So with that, we're adjourned for lunch, and see you tonight at the social affair.